May I seek your Lordship's
Just got a
indulgence?
little late today. Yes.
My Lord, if item number 7 of the hearing list be taken up on Thursday. with the
Thursday.
consent-
Oh,
Yes, my
what?
Lord.
7 of hearing?
Yes, my Lord. Criminal appeal.
Uh-huh. Okay. When do you want?
Thursday. my Lord.
Day after tomorrow?
Yes,
Okay, okay.
Lordship, in
So-
7, I am appearing for the respondent, Home Secretary and other respondents.
Which item?
Item 7.
Oh, 7. You are there for 7?
Item 7 probably orders. Contempt
Oh,
Seven
no,
of the
no,
hearing list,
7.
my lord.
No, 7 he is mentioning on of the hearing
Oh,
list.
I'm sorry.
For motion, item number 1.
Lordships,
Yes.
my lords, this is the second round.
Huh.
This relates
This
to
did
that.
not get over. When I was last time here, that issue.
My lords, I had withdrawn it and in the next occasion.
Huh.
So, my lords, we filed it again afresh. I had actually requested the notary to sign before, requested the notary to go to the jail. With me, my lords, the accused had signed before the notary.
Acha, acha, acha.
So, my lords, that technical issue, my lords, without
Huh.
getting into that
Huh.
issue, my lords, we had cured it that manner.
Okay.
So, my lords, the thing is that, my lords, this petition has been filed on 1st July, all 3 of them. There are 3 FIRs, 3 bail orders, all onerous conditions. 2 of them say a bail bond amount of 50 lakhs, plus, my lords, local sureties who are government servants. My lords, your lordships had asked a very pertinent question in the first round regarding to whether sureties are a necessity. My lords, it is discretion of this court. 3 of these, my lords, 3 of these cases, why we filed it together is that, my lords, we want to be fair. It is true, my lords, the accused's role is, my lords, he's the main kingpin, seems to be. That's the allegation. All his assets are frozen. The only issue is, my lords, it's not that he does not want to give anything, but he has to give something which he can, my lords, in the facts and circumstances, which is fair. My lords, in the first item number 1, which is criminal petition 20, here we are saying, my lords, that let me try and deposit the 2 lakhs. 2 lakhs have been made the condition there.
Now that is okay, not one.
Yes, my
on
lords.
this, yes.
But, my lords, let that order, let those conditions apply for the other 2 cases.
Okay.
And that was done in, my lords, in Girish Gandhi.
Girish Gandhi, I mean, I think there were so many affairs.
So many FIRs.
And in relation to
Multiple
other states
states,
also.
yes.
And then it was said that it is not fair that each, there has to be surety or bail
Yes.
furnishing in each, make it one.
Yes.
In respect of all the states.
Yes, yes.
Here also there are 3 FIRs.
3 FIRs, 1 state. And, your lordships, the cause of action, the whole sequence of these, though this is outside the petition, it's because of the scam which had happened within the company itself. It is not.
Now what
something-
is the onerous condition here in item number 1?
In item number 1, my lords, we are saying that out here we are saying that we are not going against the bail bond amount here. We are saying that, your lordships, the furnishing of 2 local sureties who are government servants.
Huh.
That, and my lords, it had also prohibited me from, my lords, if I were to be released on bail, from me to reside at a different address. Because, my lords, I was staying in a rented accommodation in Aizol. And I'm originally from the Assam, in, my lords, Tezpur, Rangapara, which my lords, the prosecution would not deny. We are actually seeking, my lords, if I can be somehow be able to reside there, because I won't have any source of income now here. I am out of job, my lords. My family resides there. But, my lords, even if that prayer is not allowed, at least let me reside in a different address here in Aizol. I'll make my arrangements.
But not at the present address.
My lords, the present address was, my lords, I'm being thrown out because of the, my lords, stigma that may come against the landlord, my lords.
You might be thrown out. You are
I've
still
thrown
there.
out. I've been thrown out, my lords.
Acha, acha.
I've been thrown out.
Oh, now though you are inside. Oh, you
I-
have been granted. Oh, you are inside.
I'm inside the jail, my lords.
So today what is to be done? Whether notice or when Hesami Miss can address on the issue and it can be disposed of. What?
Yes,
In
Your
the
Lordship,
motion stage.
If notice may be issued and if the matter may be fixed next week.
Acha. Notice to whom? Oh, Mahindra is made a party, right?
My lords, we wanted to be fair because they
last
would
time
file
also
their
they-
application. Yes, yes, my lords. We are making them a party. They're duly represented.
You are for the state and you are therefore.
I'm standing on behalf of my senior, Mr. Caesar Ramsano, who is the leading counsel for Mahindra. And
Today
he's-
notices are also not been issued and you are appearing. Let the notice go.
Yeah,
Right.
yeah, I received notice on his behalf
Your lordships,
because he's out of station.
we had duly given them service in advance. 1st of July we had filed it. We had done it prior to that. I'm just seeking, my lords, if your lordships can put it on an earlier date. Just if your lordships may consider granting him temporary release so that he can make arrangements, my lords. At least try to make arrangements.
He's inside since when?
My lords, since it's been more than a year,
And there has been bail orders in all the
in all the other two.
in all cases.
Yes, my lords.
But he's not been able to come out.
Yes, my lords.
This is also not fair. He has got bail orders. Because of the onerous conditions, he is not out.
My
It's
lords,
almost like not granting bail. So you take instructions within this week, Monday I'll take it up.
grateful.
Okay? So, okay, this is a petition, heard Mr. Jordan.
Yes, my lords.
Yes, answer, for the petitioner, and Ms. Venesami for the state respondent, and Ms. Okay, Arge for respondent number 2. This is a petition under section 528, read with section 438. 438 is what?
My lords, 438 we put it as a, my lords, for the completeness of the petition, but this is 438 is the revisional powers, my lords.
Acha, okay. 440, that means 397 and 401 of CRPC.
My lords, the
397 and
yes.
401.
Correct, my lords.
Okay. Okay, 528, read with section 438 and 442 of the BNSS. For modification of the order dated 22/5/2025 passed by the Judicial Magistrate First Class 3 Aizawl Judicial District, Mizoram. By the said order dated 22/5/2025, before that, the petitioner is seeking for modification of the onerous conditions given in the order dated, given in the said order, by which the learned court, you got that. The petitioner has challenged 2 of the onerous conditions mentioned in the said order dated 22/5/2025. 1, the learned court provided for 2 sureties while provided for, where is that?
My lords, page 43.
43, okay. Had provided for furnishing of 2 reliable sureties who are regular government servant posted in Aizawl district, as well as direction that the petitioner may not leave the jurisdiction of the court or relocate his address presently in the police record without the permission of the court. Ms. Veneshami appears for the state respondent, and as such, no formal notice is required to be given. Extra copies not required. You have.
Not required.
Okay. Then, Ms. So-and-so, appearing
Okay,
for
that is-
my, appears for the respondent number 2. You also don't need, you have copies?
Yeah, I have copies,
Okay.
my lord.
Respondent number 2 and Miss so-and-so or appears, don't write appears. Miss so-and-so appearing for respondent number 2. Not required. Appears for respondent number 2. List this matter on Monday, that is on 4th of this August 2025. No affidavit, I don't think so. Orally you will submit? Okay. So list the matter on 4th. You are already there on board. Okay.
My lords,
For,
these
huh?
other two items,
Ha, ha.
it's more or less similar. Order may be passed. The conditions are at page 36.
There I think 50 lakhs.
50 lakhs and my lords, two sureties who are Group A officers working under Government of Mizoram, posted at Aizawl and duly certified by controlling authority.
You are mainly challenged which grounds?
Page 36, my lords.
Page 36. So the first one, 50 lakhs.
First and second, my lords.
His accounts are freezed, right?
Freeze,
You
my
said?
lords. Everything. All his assets.
And the second one also.
Yes, my lord. Second. Group A officers.
Right again. Third will remain same. This is an application again will be same 528 and so and so. For modification, the first part will remain same. The petitioners have challenged has mainly challenged two grounds, two conditions attached to the bail order, bail order, wide order dated 15/10/2024. The two conditions are: the petitioner was directed to furnish a bail bond of rupees 50 lakhs to be deposited by check at Mizoram Rural Branch, as well as the petitioner was directed to furnish two sureties who are both gazetted Group A officers. Who are both being gazetted Group A officers. Two sureties being gazetted Group A officers working under the Government of Mizoram and posted at Aizawl and duly certified by controlling authority. Full stop. The petitioner has stated that both the conditions are onerous and has prayed for modification of the same. Same like Ms. Venishami appears for the state respondent and Ms. So-and-so appears for respondent number 2 or 3 also. There are,
Yes.
who is respondent
My
number
lords,
2?
But, respondent number 2 is the main complainant. 3 is my lords Mahindra.
You are appearing for 2 as well?
Doctor Englaw. My lords, if we may, My
I'm not
lords.
sure, my lord.
Hmm?
I'm not sure if I'm appearing for the other respondent.
2 is the complainant.
main complainant.
And he is what? He is an employee of the 3?
No, my lords, it's a private individual. What I can do is, my lords, registered AD notice I can issue to him. my lords.
Okay. You can serve it in 1 week's time?
Yes, my lords.
Okay, then Ms. Venishami for respondent number 1 and Miss So-and-so for respondent number 3. Notice be issued to respondent number 2.
My lords, if I may give it through Dusty. In fact, that'd be best.
Criminal case actually Dusty is not there, right?
My lords, then I'll go for registered ED, my lords. And that may be correct, my lords.
Usual process.
Usual process.
A notice issued to respondent number 2. Petitioner may take steps for service of notice upon respondent number 2 by registered post with AD or by usual process. Full stop. List this matter on Monday. Along with these three will come together on Monday.
My lords, the third one, I'm sorry, your lordships, the similar petitions. And I'll just take your lordships to that page. Page 31 are the conditions, my lords. Page 31 and 32.
31. 31. No.
31. Impugn order, my lords.
32, I think.
31, my lords, 50 lakhs at the end of the.
Oh, yes.
Then at 32. At 32, my lords, we are saying, we are challenging.
This is not an interim order, right? Acha,
No.
Regular bill.
Regular.
Yes. What?
So, my lords, we are challenging most of the conditions apart from number 3.
Acha. Only 3 is left out?
Yes.
1, 2 and 50,000.
And, my lords, at the end of 32 is the sureties
Shall be a permanent resident.
certified by the chairman, local area council. In addition to the certificate of the chairman, put up as security for bail his own land settlement certificate, which must be in the opinion of the court of the same or greater value than the bond amount.
Okay. And also one that you have to appear every day at 9, right?
Yes, my lords. Because the charge sheet in this matter, my lords, in this case, has been filed.
This case is that it has been filed.
Yes, my lords.
Other 2 is not filed.
My lords, item 1 has been filed. Item 2 it's not yet been filed. Item 3 it's filed.
Okay, right. Front initial part will be the same. For modification of, for modification order is different.
Yes.
For modification of the order dated 10/6/24.
Yes.
Passed by District and Session Judge, Aizawl Judicial District, Mizoram. The petitioner is aggrieved by the conditions imposed upon him while granting bail and has challenged the same in this petition. The conditions The conditions which according to the petitioner requires modification are: number 1, the petitioner was directed to furnish a bail bond of rupees 50 lakhs duly guaranteed by suitable surety. Number 2, the petitioner was directed to report to the Crime and Economic Offences PSCID every day at 9 a.m. Number 3, the petitioner was directed not to leave the jurisdiction of SP, CID or relocate his present address in the present address without the permission of the police. And number 4, the petitioner was directed to furnish surety who shall be a permanent resident of Aizawl, duly certified by the chairman of local area council And also that the surety shall put up as security for bail his own land settlement certificate which must be in the opinion of the court of the same or greater value than the bond amount. The modification of these conditions are prayed for by the petitioner.
Your Lordship, if I may, the order which he have challenged was not annexed here. It's not annexed here, and moreover, there is no page number in the copy which I have received.
Oh, otherwise it's okay here.
My lords, I'll give them a fresh copy.
Okay.
Could be
And-
some printing
And there
problem,
is
my
no
lords.
page number in each and
A
every
proper-
petition.
My lords, I'll
proper
give them a
copy.
fresh petition. my
Okay.
lords.
Ms. Venishami appears for respondent number 1. And you are for respondent number
2. Mahindra.
2. The petitioner may serve proper copies upon the respondents and the matter to be listed on 4th, on Monday.
My lords.
Item number 4.
My lords, item 4 is the, again, we had filed this, withdrawn it and filed it afresh. My lords, here it's again related to Mahindra case. Here we are seeking that, my lords, here the petitioner, he's been, my lords, imputed in two cases. One is CNEO 3 and FIR 96. We are saying that, my lords, the second is emanating from the same cause of action.
So second FIR not maintainable.
Yes, my lords. And the charge sheets itself, my lords, ditto same, my lords, ad verbatim, it's been reproduced, the allegations. And my lords, similar petitions are pending and they are coming up, I believe, on 8th August. One of them is criminal petition number 8 of 25.
Acha. Similar by same petitioner.
No, my lords, these are different accused, same standing. He's a car dealer, my lords, in the...
Acha. Mr. Madhurya Sharma is who? He is the complainant.
No, my lords, he's one of the accused.
Acha, he is one of the
Yes.
accused, yes.
So, similar co-accused,
He is a car dealer.
car dealer.
And then by submitting fake certificates, they got money from the, they got loan from
My
the.
lords, this is the
This
allegation.
is the allegation.
Yes.
He has a car
Yes.
dealership.
Yes, my lords.
He is otherwise doctor, not a physician.
My lords, he's also a doctor, he's a radiologist.
Acha.
But actually the allegations are against the company in which he's a director.
Acha. Okay.
Yes.
So this is for challenging the second FIR.
Yes.
And let it come up then again with on 8th of August
8th of
along with
August.
the
Yes, my lords.
other. 8th of August is what?
8th of August is,
Monday.
my lords. Friday, my lords.
Friday.
Next Friday.
No, not Friday.
My lords.
I think Friday.
Friday.
Oh, Friday there will be some difficulty otherwise.
Yes, my lords.
Because there is the inauguration of the Itanagar
Oh, yes, my lords.
Itanagar High Court.
Bench, my lords.
So we all will be leaving on Friday, I believe.
My lords, the parties are all here. We can give instructions adequately. my lords.
So do it on the week after that.
Yes.
11th you do it.
Yes, my lords.
Okay.
11th.
So so right, this is an application under section 428 of the BNSS 2023.
520.
528
Yes.
of the BNSS 2023. Read with section no, not required and 482.
Yes.
For quashing of the second FIR, that is crime and economic offences, CNEO Aizol, police station case number 3 of 2024. and all proceedings emanating therefrom. Full stop. The petitioner states that the first FIR which was lodged on
My notes, first FIR was lodged on my notes 20th March 2024.
where is that?
My notes list of dates, my notes page B.
The first FIR which was lodged on 23/2024
Yes.
and against which the Aizawl police station case number 96 of 2024 was registered. Don't write which. The first FIR was registered under so and so. The petitioner states that the first FIR dated so and so was registered under so and so against the petitioner, and that thereafter a second FIR dated 29/3/2024 was also registered against the petitioner as CNEO police station case number 3 of 2024. It is submitted by the petitioner that the second FIR is on the basis of the same facts and allegations. And as such, the same is not maintainable in view of the law laid down by the Honorable Supreme Court in a number of decisions. Issue notice. Issue notice now. You are appearing. Miss Venishami appears for respondent number 1 and Miss. What is her name?
Rinsange.
Insani.
Rinsange.
Rinsane is difficult to pronounce. Insane for petitioner number 2 or for respondent number 2. Extra copies not required?
We've served them.
It is stated at the bar since the analogous petition is fixed on
8th August.
is fixed on 8, but then I'm fixing it on 11,
Why
right?
not?
So 8 you make a prayer and then we'll
Yes,
do
yes.
it. And don't write that analogous petition. List the matter on 11th of August 2025.
Grateful, man. Deeply obliged.
For omission, item number 5.
Yes, my lord. I have taken instruction from my client, and as respondent have complied with the order passed by this court, this matter may be closed accordingly.
Acha, the contempt is complied, I mean the directions are complied with.
Yes, my lord.
Show me that, whatever. Yes, Miss Linda. Yes, it is complied with. What is the
Yes, my lord.
directions?
Complied. We have prepared a draft of what?
Some calculations.
Yes,
Where is the directions, Miss? Yes. Show me the directions of the High Court.
Go ahead.
My lord, we have submitted the award on the last court date, my lord.
No, before I go into this, I just wanted to see the directions. Show me the directions from the of the court against which you have filed this willful disobedience.
King Mangia petition.
In WPC 53,
Which is the page? Page 15. You have not gone through or what? Hmm? By Justice Silo.
My lord, in WPC 53 of 2014.
Yes.
Oh, yeah. Order was dated 13/4/2018.
Got it. What is LSC?
Land settlement certificate.
So a market community was constructed on that land?
Yes.
Yes.
It was decreed, the land was decreed in their favor, right, in view of the settlement certificate?
Yes, ma'am.
although against that judgment and order of 2011, there was no appeal preferred.
No
Right.
appeal was preferred.
And during the pendency, illegally they constructed a market. Then how come how did it come before the High Court?
No, my lord, not during the pendency.
No,
Prior to that.
pendency they had made those, constructed those all. Then how did it come before the High Court?
Your lordship will see in their petition, they have mentioned here, my lord, at para 1.
Paragraph 1 of their pleadings,
Yes,
their
my lord.
petition.
The contempt petition.
Huh.
The main, the facts are mentioned here.
No, I'm reading the High Court's order.
The petitioner is the legal and lawful owner of this property, LSC number 10
Yeah,
of
that till that
1970.
it's okay. The court had given them the decree and all. Right. That during pendency they have illegally constructed.
Not
Then
during the pendency, my lord.
it's written, see, during the pendency of the civil suit.
Civil suit, yes.
Civil suit.
Yes,
Yes.
yes.
Achha, during the civil suit they had constructed that market, and against that construction they have come before the High Court.
Yes. What happens is that, my lord, there are two LSCs overlapping.
No, one is DLS.
yes. The
yes.
department was issued DLP.
DLP.
Yes, 19 of 1997.
DLP was for 25 years, and that too it was given after
After.
it,
yes.
the settlement certificate was in her favor.
Yes, yes.
That was given in 70s
Mhm.
and again 78. But then they did not come for execution of the decree, right?
Yes.
And because they said that the person who had demolished the authority was not made a party.
Mhm.
Acha. Okay, so what is the final order from a perusal of so and so? Settle in favor of so and so, state respondents could not. Why it is so hot? Mr. Courtmaster. Mr. Courtmaster. It's so hot. Switch on this fan. Okay, so where is the compliance of this order?
My lord, we have given a copy to this honorable court on 26/5/2025.
Already given?
Yes, my lord.
Oh, it was not dated, they said,
Yes,
right?
yes, there was no date, so
Acha,
they sought some time to seek instructions.
Okay, this was the one or what?
Yes, your lordship, that's the one.
This is the one.
Yes,
The proceeding on acquisition of land.
yes,
Okay, the direction was to initiate steps to acquire the land, right?
Yes.
Of the petitioner covered by so and so as per so and to pay him compensation. The entire process shall be undertaken as so and so So you have initiated the process of acquiring the land.
Yes, ma'am.
Mm.
This was although, what is the date here? What they said that it was not dated, but then what is the date then?
18/6/2025, my lord.
Huh?
18/6/2025.
Okay, you have checked, right?
Yes, my lord.
Okay then. Right. This is an application filed under Rule 9 of the Contempt of Court within bracket Guwahati High Court, Rules 1977, read with Section 12 of the Contempt of Court Act 1971 for non-compliance of the Guwahati High Court order dated 13/4/2018, passed in WPC number 53 of 2014. The direction given in the said writ petition was that the respondents, state respondents, within a period of 1 month from the date of receipt of the certified copy of the said order, was directed, were directed. I've already said directed before or what? Just read the line. Okay. Within 1 month to initiate, don't write direct. To initiate steps to acquire land of the petitioner. To initiate steps to acquire the land of the petitioner covered by LSC Land Settlement Certificate number 10 of 1978, as per the law applicable, and also to pay him the compensation. This court further directed that the entire process shall be undertaken as expeditiously as possible and within the outer limit of 5 months from the date of initiating the acquisition proceeding. And whether the second direction is fulfilled.
Yes,
Within 5 months, they have to undertake the entire process, whether that is fulfilled.
my lord, with that regard, it's here. This was issued in 18/6/2025. So we still have time, my lord, for that to complete.
But then see, there are two parts in the direction. So within 1 month, you have to initiate the process for acquiring the land. that okay, within 1 month it is not done, but then it is done. But again, the second thing is, entire process shall be undertaken as expeditiously as possible, entire process of acquisition, and within the outer limit from the date of. So whether initiating is done, but process is undertaken, right?
Yes, madam.
By this notification, it shows that process has also been undertaken. Acha, theek hai. Then what did I say? Within outer limit of 5 months.
Yes.
Yes, full stop. The said directions were given on 13/4/2018. The said contempt petition is taken up for adjudication. Oh, no. The said contempt petition was filed on 30th of October 2018. And the same was taken up by this court full stop. When did you give this notification? And they took time to check the date.
Notification was produced
Hmm?
on
Acha.
26/5.
26/5.
Yes, 26/5/2025.
On 26/5/2025, when the instant contempt petition was taken up. The counsel appearing for respondent number 11. Miss Linda, you are for respondent number 11.
My lord, we are for all, yes, respondent 11, all the respondents in fact.
Achha. The learned counsel for respondent number 11 had placed on record the copies of the awarded amount No, this is for awarded amount, right? And this application is for awarded amount is the second page. This is compensation. This is compensation, right? Compensation of 23 lakhs.
The second part,
Yes,
this is the award, yes, the total compensation amount.
And the first page is on your initiating
Yes,
and the process.
the proceeding, yes.
You have gone through the entire things, right? And
Yes,
you are
madam.
satisfied and
Yes, my lord.
okay. So, but see, 18/6/25 orders reflects only about compensation, right? It doesn't speak of the initiation of the acquisition proceeding. Whether it was given earlier than 26.5.
My lord, in our affidavit, the show cause affidavit, dated
An additional show cause reply you had filed.
by respondent number 11. We have mentioned
There
that
you have annexed this copy.
this 18.6 is not annexed, but we have mentioned that at para 7, the award amounting to rupees 23,72,000 so and so has been approved.
Yeah, the same one which is reflected here, right?
It's the same amount.
Mm.
This has already been approved.
Okay, I said 26.5 order, right? Yes, what did I say? On 26.5? Place on it copies of the awarded amount which has been calculated by the Deputy Commissioner in compliance of which has been calculated by Deputy Commissioner in compliance with the order dated 13/4/2018 passed in WPC number 53 of 2014. However, the learned counsel for the petitioner on the said occasion had prayed for time to get instructions regarding the said awarded amount, as according to the said counsel, the copy presented by the concerned respondent was not dated. Today, when the matter is called up, Miss Linda appearing for respondent number?
My lord, 11.
Respondent number 11 is the Deputy Commissioner.
Deputy Commissioner.
Maybe later on implemented or what? Oh, 11.
Yes,
Acha,
later on it's an
Yes, 11 has placed an order by which it is reflected that proceeding on acquisition of land under Mizoram Land Acquisition, Rehabilitation and Resettlement Act 2016 with regard to the present petitioner in reference to writ petition number 53 of 2014 was passed. In the said notification, it is also reflected that the land value of the said land in question is also determined. By the said order, 100% solitium for the petitioner as per section 30 subsection 1 of the said act is also considered. Along with 12% interest. Further, by the said order, the compensation was also fixed at rupees 23,72,863. It is given to the petitioner
Yes, my
or
lord.
is
I
to
have
be
received.
given.
I have received.
You have received. Was already given to the petitioner, which is also stated by the petitioner that, it is stated by the counsel appearing for the petitioner that the petitioner has received that amount. In view of the same, that is, acquisition proceeding was initiated as well as compensation given, and also the process was also and also that the process was undertaken as ordered by this court by order dated 13/4/2018. Since there is compliance of the order stated above, this contempt petition is closed. Petition is disposed of.
Obliged.
For orders, item number 6.
Lordship, while
This is again CJM's order. Yesterday also I found few cases
Lordship,
where
yes.
appeal is filed before High Court against CJM's order.
Lordship, yes, it was fixed on 4th of August, Lordship. Then I'll be prepared for on that.
No,
And
whether
Lordship,
there is provision.
yes, it's a provision 419 of the BNS.
Okay,
Lordship.
419 I had seen yesterday. Just give me BNS.
Yes, Lordship, yes.
BNSS.
BNSS. Lordship, we have two options. One is to approach the Sessions Court, and the other is to approach this Honorable Court, Lordship.
Both.
Yes, Lordship.
419.
4191B.
419.
419 subsection 1 and B, Lordship. This is an appeal filed by the Union of India, Lordship State.
Under the Central Act investigation.
Yes, Lordship, yes.
So 419.
419 1B.
Save as otherwise provided in subsection 2 and subject to provision of subsections 3 and 5. You are referring to?
419 1B, Lordship. The state government may in any case direct the public prosecutor to present the appeal to the High Court from an order, original or appellate order of acquittal passed by any court other than the High Court, not being an order under Clause A or an order of acquittal passed by the Court of the Session in revision. So,
This is the state government.
this is a state guide, this Union of India, Lordship. And Lordship, the coordinate bench of this Honorable Court already discussed the maintainability in this regard, and it
Is
also,
it?
yes, Lordship.
Where is that?
Lordship.
Acha, no, you will come under subsection 2. If
Also-
such an order of acquittal is passed in a case in which the offence has been investigated by
Lordship.
any agency empowered to make investigation into an offence under a Central Act.
Central
so
Act,
you are
Lordship.
doing it under the Customs Act.
Under the Customs Act, Lordship.
So you will fall under 2. Other than this Sanhita, the central government,
The
here
central
you
government. Lordship, yes, the central
come. Your
government.
Union of India.
Union of India, Lordship,
The
yes.
central government may, subject to the provision of subsection 3, that is leave, also direct public prosecutor to present an appeal
Lordship.
to the Court of Session from an order of acquittal passed by a magistrate.
Lordship, yes.
Yes, okay. B,
And B, to the
High Court from an original or appellate order of acquittal passed by any court other
Lordship,
than a
yes.
High Court,
Lordship, yes.
not being an order under Clause A or an order of acquittal passed in revision.
Lordship, from my humble understanding,
What is
Lordship,
The district
is
magistrate.
district magistrate. It is
So
not
direct.
Lordship.
So that is okay.
So you
to
have
present
two
an
options,
appeal.
Lordship.
So what you mean to say is you come under 2B.
To be.
2B, not 1 in B.
Lordship, yeah, it should be 2B, Lordship,
2B.
2B.
From an original.
From original, Lordship.
Original is by CJM.
Yes, Lordship.
Or appellate order of acquittal.
Yes. This is the session court, Lordship.
Or appellate order of an acquittal passed by any court. Means if the CJM court convicts and the session court acquits, then you can come against the sessions court order.
Sessions court order, Lordship. Or to the High Court.
from an original
Lordship, yes.
order of acquittal from CJM.
Lordship,
And what is the cited judgments? Just show me that. Guwahati High Court.
Yes, Lordship, coordinate bench of this Honorable Court in the case of, let's see,
Achha, this was not there in CRPC. Show me CRPC. Give me CRPC.
CRPC.
This will be a 378.
Yes, 378, Your Lordship. Under the CRPC, 378.
Yeah, it's there. It was there. Same.
Same, Your Lordship, same. Lordship, in the judgment and order, para 2 and para 3, Lordship, though it was not mentioned that it is disputed or it is not maintainable or not, but Lordship, this coordinate bench of this honorable court had passed appropriate order.
No, on
Under-
maintainability. This is not on maintainability.
Lordship, yes, it is not on the maintainability, but Lordship, it was discussed earlier, but it was not reflected in the order.
Acha.
The operative is at Lordship, page, paragraph number 32 and 33. It was this order of the order passed by the CJM Champai was set aside.
Ah,
Lordship.
in the facts of this case, okay. Why don't you bring some citations on this, that it lies before the High Court? Of course, in a bare perusal, 419.
And Your Lordship, at this stage, in the last court order, I was given a chance to submit the affidavit of service of notice upon the respondents, Lordship. And I have received the service of return from the respondents. So I may be given a 3 days time to file the affidavit, showing that the respondents had.
No, first of all, okay. Acha, what happened? You had served copies upon?
Lordship, yes. And I have recently received the service of return from the department. And I may be
Through
given.
Dusty?
Through Dusty, Lordship.
Acha, a criminal case, no dusty, right?
Lordship, we have tried to serve through the AD, through the registry of this honorable court, but it was not able to return.
Okay.
So I
This
asked
is a case under customs.
customs, Lordship.
Today it has come up for condonation, delay,
Lordship,
condemnation of
yes, yes.
delay.
Delay, Lordship.
273 days.
Lordship, yes.
Service is complete.
Service is complete, but I have not filed the affidavit of service of notice.
Anyway, you are for Union of India, right?
Lordship, yes.
And then there is only one respondent.
There are 3 respondents, Lordship, and the respondent 1 is already passed away, Lordship, and respondent number 2, we are not able to trace the respondent number 3. So then I will.
Do it
I will
through the dusty you have served upon whom?
for respondent number 2, Lordship. Only respondent number 2.
3
One.
you have.
1 already passed away,
So that will be over.
Lordship.
Only 2 and 3.
3, Lordship, and 3, we are not able to trace the whereabout of the respondent number 3. Lordship. Only 2 is
See
remaining.
his address given in the FIR or in the charge sheet. You have seen.
Yes, I have seen, and my officers went to his residence in the reflected residence, Your Lordship. It's
Not
not
there.
available. And we have approached the local village council authority, and they said that earlier he was in their village, and he already left the village. Then they do not know the whereabouts of the respondent, Lordship. And I
Do
will
it
file the
through the,
affidavit. I will file the affidavit in this regard, Lordship.
Do it no services. This is against acquittal, right? And
Lordship, yes.
he is doubly announced not guilty. He is innocent.
Lordship, yes.
First stage,
Yes,
even in
yes.
second stage,
Yes.
so doubly he was declared innocent.
Very true, Lordship.
So it has to be served. Do it through the police officer.
Lordship,
He will be able to search.
that will be proper, Lordship, because from the department side we have tried our level best. We are not able to trace.
Do it through the police station.
Um,
As far as 2, it is already served. You file an affidavit.
so yes,
And 3, you serve it through the police.
yes,
okay.
Lordship, no problem.
So this is an application filed for condonation of delay of 273 days in filing the connected criminal appeal. By which the impugn judgment and order dated 25/1/2024 passed by Chief Judicial Magistrate Shamphai in criminal complaint number 2022 was prayed for. Full stop. By the said order, the respondents number 1, 2 and 3 were acquitted, and against that the present criminal appeal is sought for.
Yes.
Notices were already issued to respondent number 1, 2 and 3, and the counsel appearing for the your CGSC,
Special PP, Lordship.
the
Union
special
of India.
PP appearing for the appellant submits that respondent number 1 has expired, and as such he submits that the case is abated. Whether it is said abated in an acquittal case? No, no.
No,
He is
I don't
already innocent, not required. He has expired.
Yes, expired on 21/6/2021.
21/6/2021. Full stop. As far as respondent number 2 is concerned, the counsel submits that he has served the notice by dusty mode
Lordship, yes.
upon him, and he may be allowed to file an affidavit to that aspect,
Lordship, yes.
which is allowed. As far as respondent number 3 is concerned, the counsel submits that he is unable to serve the notice upon him in spite of his best efforts. He further submits that on inquiring with the village personnel, he was informed that respondent number 3 has left his place. As such, it is directed that notices upon respondent number 3 may be routed through the concerned police station for service of notice upon him.
Lordship, yes.
The petitioner to take steps for service of notice as mentioned above. List this matter after 2 weeks.
Lordship, yes.
You will give it to the police, and perhaps you have to give it to the registry. Registry will route it through the police.
Lordship, yes.
Item number 7.
Clear, Your Lordship.
Yes, Mr.
In both the cases, I am appearing for the Home Secretary.
You are appealing for the, what is this IA about?
So, Lordship,
Actually,
this is application for implement of the
New incumbents.
New incumbent.
And Mr.
Lordship,
Kial, you
I
are for?
was supposed to file Kalatnama on behalf of new Home Secretary. Lordship, they sent through the speed post, but till date it has not reached the Aizawl, Lordship.
Acha.
And in the meantime, Lordship, the another officer of the Home Ministry, A.K. Dhyani, respondent number 12, he is also retired. And Director General of Assam Rifle is also new person is joined, Lordship.
When was the this is what, complaint petition, contempt petition?
This is a contempt. There are 2 contempt, one of 17 of 2016 and 3 of 2014.
Acha, 1 second. This is item number?
Item number 7.
So this is a criminal appeal? What?
No. This is the contempt. Lordship.
Oh, this is, I'm holding on this one. This is contempt case. When was it
Yes.
filed? 2016.
Yes.
See,
They- yeah,
2016 things are not complied, officers are being changed.
No,
How
Lordship,
long will
Lordship, the matter was extensively heard by this Honorable Court on 23rd 10 2024.
Then what happened?
Lordship, I am pleased to see there is a direction to the Deputy Commissioner to submit some documents, but they have not complied with this order also. And in that order, Lordship, we have submitted, there was a full-fledged argument. And after hearing both the sides, this Honorable Court fixed the matter for pronouncement of judgment. Lordship, I am pleased to come to paragraph 14 of order dated 23/10/2014.
No, it's
2024.
Okay it's okay, today they have come up for pleading again. The matter
Lordship,
has to be heard
I may be
as
able to
soon
use
as
time to
possible.
file my wakalatama for the new implemented new respondent, Home Secretary Mr. Govind Mohan.
And it should be disposed of as soon as possible, otherwise again officers will change.
Yes, yes, Lordship, and there was a full-fledged hearing on 23rd 2024.
But then it was over, now that new person has come.
Now, Lordship, here, we are, Lordship, I have obtained instruction, we are, will go by the affidavit already filed before this Honorable Court. Lordship.
So you are appearing for respondent number
And now he is respondent number 16.
6. Oh, acha, the newly implemented, it is yet to be done.
Lordship.
So today he has filed for an impleading, application
No, no.
for impleading.
That petition has already been allowed in contempt number 7. In 3, probably they have not filed the this Honorable Court on last occasion.
No,
Given
as far
liberty.
as this I is concerned, for impleading, Govind Mohan,
That
secretary.
was allowed.
That was not allowed, there is no order here.
This is the
Lordship,
first
I
time.
was informed on last occasion that
It's the
that
first
petition
time.
has been.
This is the first time.
Then Lordship,
This is for
I may-
contempt number 7.
This is for contempt number 7. So I'll allow this impleading application.
Yes.
You
Yes,
changed
that may
the
be
cost
allowed.
title.
Is my letter friends, they did not have objection.
Acha, okay. This is an I may likho. This is an application under Order 1 Rule 10(2). Order 1 Rule 10 within bracket 2 of the CPC for impleading. The present incumbent, the present not incumbent, the present secretary.
Home
to
Secretary,
the-
Lordship.
Uh-huh.
He is a Home Secretary.
But he writes only secretary.
Secretary to the Government of India, Ministry of Home Affairs.
Secretary to the Government of India, Ministry of Home Affairs. Namely, Shri Govind Mohan as respondent number 16 in contempt case number 7 of 2016. It is stated by the counsel for the petitioner that the erstwhile secretary to the Government of India, who was he here?
Lordship, he was respondent number
Ajay Kumar
11.
Bala.
11.
11.
What did I say? The erstwhile?
Home Secretary.
Arrayed as respondent number 11 had retired.
Yes, he's here.
Lordship, he has retired and joined as Governor of Manipur. Lordship.
Has retired, and in his place Mr. Govind Mohan has joined. Full stop. The impleading application is allowed. The petitioner to correct the cause title, amend the cause title of the criminal of the contempt case 7 of 2016. 2016. The I is disposed of.
Obliged.
And hear it, I mean, do the hearing fast, otherwise again some other person.
Lordship, I have already obtained instruction. I am
Steps may
appealing for
be taken
him.
within this week.
Huh?
Steps.
You will amend the
Lordship,
cause
Yes.
title.
not required. I am appealing. I am accepting notice on behalf of newly implemented respondent.
Oh, you are already accepting?
Yes, I am
Okay.
accepting. On
Mr.
last occasion, Lordship, it was directed me to file wakalatnama.
Mr.
Lordship, unfortunately,
Mr.
they have
SKR,
discussed through.
he appears, So he will file wakalatnama. You give him a copy.
Yes,
Bas. Mr. S. K.R. appears for the newly. He has not been implemented also. How can I give the?
Lordship, but on last occasion, my learned friend submitted that petition has been only allowed, and this one will go directed me to file wakalatnama.
Today it is the first time.
Then Lordship,
You file the wakalatnama after it is implemented. Okay. I have allowed the implementing application. Post title is yet to be amended.
just for information to your Lordship.
Yes, I'll remember.
Okay.
Maybe
Responding
he
number,
accepted the notice on behalf of
No,
16.
you first implement. Thereafter, we will send him the notice.
Lordship, in this case, respondent number 8 and 12, they have also been replaced by new officers.
May it please, Your Lordship. This is the second contempt. This is contempt 3 of 2014.
Acha, let me
Just-
close this 7 first.
Yes, Your Lordship.
This is 7, right? You add that after implementing, the council, the petitioner may take notice, take steps for service of notice upon respondent number 16 by registered post with AD or with usual process. Okay. Then you file.
Okay.
the
What's
In this contempt number 3 of 2014, Your Lordship. In this case, the present incumbent has already been implemented by order dated 4/3/2025.
Oh, this is what he is talking about.
So, just to briefly take Your Lordships through the facts, Your Lordship, it's very short.
No, whether it is taken up for disposal.
It won't be, because the reason why I'm trying to, the point that I'm trying to impress to Your Lordship is that as far as this case is concerned, there is only one question, the question of payment by the Home Ministry. That is the only question.
Payment in respect of?
Payment, yes, coming to that, Your Lordship. What happened is that we are landowners. So during the period of insurgency from 66 to 85, our lands were occupied by the security forces for various purposes. So we approached this honorable court and filed WPC 8 of 2010. Now, in that judgment, the direction was that there should be a joint verification team comprising of the Union of India, state authorities, as well as the landowners. Accordingly, the JVT found that out of the 25 petitioners, the present petitioners' land, who are 4 in number, their lands were actually occupied by the armed forces, and that report has also been submitted. That was prepared by the DC as a result of the joint verification team's finding.
So admitted fact, your land was occupied by them.
Land was occupied. Now, the issue now is that, number one, they have not filed any appeal. Till date, since 2011, they have not filed any appeal. They have not challenged the verification report also. And now they're filing one affidavit after the other saying that we're questioning the genuineness of the pass, it was not properly issued. All these things they're trying to bring out in the contempt, which is not allowed. And this has been going on for so long, Your Lordship, that the Home Secretary, during the pendency of this case, the incumbents have changed 3-4 times. That's the reason why all these implements are coming up again and again. In fact, my learned friend was also present in the last court date, wherein he had paid for submission of wakalatnama. That is well and good, Your Lordship. He can definitely file it. But at least come with some instructions on payment, Your Lordship. He can obtain instructions. Since he has already mentioned that he will be representing the Home Secretary, please come with some concrete instructions. If they want to file an appeal, please do so. It is their rights. If they want to challenge the verification report, please do so. But you just cannot sit idle. They're saying that I'm not accepting the report, but I'm also not paying you the money. Now, coming to the verification report.
On the last occasion, he was supposed to file, Mr. KL was supposed to file the power.
Correct.
So whether it was filed?
no, Lordship, that has been sent through speed post, but till date, Lordship, it is not is the ideal office, Lordship. Well, Lordship, we fix the matter for hearing because I am undertaking to appear on his behalf. And Lordship, this matter was also extensively heard on 23rd, 2024. Lordship, we come to paragraph 7.1.
It's okay. Today, what I'll do is you file the wakalatnama.
Lordship.
Okay, as soon as possible. And after that, no time. You file an affidavit also whether it was complied with.
Lordship, we will not
It's not
file any
compliant.
extra
It's not
affidavit. All the
compliant. It's not compliant.
affidavit
There's no
on
point in
record
affidavit.
will rely on that, Lordship.
So you will not file, whatever you have filed, you will rely on.
Yes, that is on the record. That will be, I place from that affidavit, Lordship.
But today, what I'll do is let him file the power, but because it's reflected in the
That is
last
also,
order.
that is absolutely fine, Your Lordship. My humble prayer before Your Lordship is that please let there be a recorded in the orders that he comes back in the next court date with some concrete instructions.
Lordship, with regard to I have objection. Lordship, the matter was heard on merit also. By this one
How can there be a question of merit in contempt?
The contempt you have.
Lordship,
There's no question of
we have
merit.
Lordship, there is no contempt at all.
All right.
If Lordship finds that we have committed,
Why
Lordship,
there will be
we are
no-
open that Lordship may issue contempt notice
So
against
what happens to the
order.
judgment and order of this court?
There is an order of this court, you have to follow this, and if you have
No,
not
Lordship,
willfully
Lordship.
followed, then
Lordship,
there is
yes,
contempt.
Lordship, we have to follow the order, Lordship, but where, Lordship, this one got directed for joint verification. Lordship,
Done.
placed from the record that there is no contempt was committed by Home Secretary and its officers, Lordship. And Lordship, may please to come to
Okay,
paragraph
if,
7.1 just
the,
for.
order was complied to be by whom?
Complied by the respondents, that is the home. Because 1966 to 86 was regarded as internal conflict. So it comes under the jurisdiction of the Home Ministry.
So the directions were to the home. So you are representing that. So where,
Yes,
how
Lordship.
can you say there is no contempt?
Lordship, may please to see the records and affidavit of the
It's
Deputy
okay,
Commissioner also.
You file contempt on the next occasion, you come with instructions, proper instructions.
Lordship, I have the
Then-
instruction with me, Lordship.
Then
Yes?
The matter was heard by this honorable court on 2010-2024. Lordship, just for perusal, Lordship, may please to come to paragraph 7.1.
7.1 of the order, what?
The date 23/10/2024.
The order,
Yes, Lordship.
order dated
23/10/24.
23/10/24. By Justice Fokon. Yes,
Lordship.
then
Paragraph 7.1 onward, Lordship. Married, Lordship.
no, what is the last? According to provide respondent number 5, the Deputy Commissioner Lungle and respondent number 11, the Secretary of
Yes,
the
Lordship.
government of within a period of mid-fortnight from the date of receipt of the certified copy.
everything is there, Your Lordship. Everything is on record already.
Minutes of the meeting of joint verification team. Along with joint verification is already done.
I have annexed it in my contempt petition.
So joint verification was done after this order.
No, Lordship.
No, as per the directions of this honorable court, joint verification was done.
So it was directed that the Deputy Commissioner shall also enclose the minutes of the meeting of the joint verification held on 2/5/2013. Okay, it was held before. Along with an affidavit immediately after that, this was so and so. So this was done
No, Lordship. They have not filed any affidavit, Lordship, till date.
about the joint verification.
Lordship, this direction was never complied with by respondent, Deputy
My Lord,
Commissioner.
Your Lordship, if I may, Your Lordship, with Your Lordship's permission, if Your Lordship can kindly turn to page 39 of my contempt petition. This meeting minute I've already annexed.
Or meeting minutes were next.
It's already annexed. It's been there since 2014.
Minutes are there.
Yes, Your Lordship, this 2/5/2013, this is meeting minute of the joint verification team dated 2/5/2013, page 39, annexure 5.
So it was already there before the order was passed.
Even before the order was passed, this maybe the possibility is that, Your Lordship, this order was passed CAV. It was not passed in open court. Maybe that's why. Maybe that's why we could not assist this court in clarifying that issue. But in any event, this meeting minute is already there. And they have not challenged this also. And also, Your Lordship, what I would like to mention is that the verification team had suggested payment to 5 persons in this same meeting minutes. The amount assessed by the Deputy Commissioner has already given to the the name reflected at serial number E. So how can you say that I'm accepting part of the meeting minutes, but I'm not accepting the rest? Can you do that? They have they have not challenged this also. I'm partly accepting this, but the remaining portion I'm not accepting. How can we do that?
It's okay. Today, as of today, there is no way out. I'll have to allow him to file a wakalatnama, and we will come with proper instruction on the next date, and the matter can be heard finally.
Yes, Your Lordship.
Yes, yes,
So
Lordship.
heard Mr. So-and-so for the petitioner. Your name is Aziu.
Lal Fakoma
Huh?
at the bottom, Your Lordship.
B. Lalram.
No, my lord. It's the third contempt case number 3 of 2014.
Oh, yes.
The first
Third.
name.
Okay. Lal Fakama.
Yes, Your Lordship.
Yes. Mr. Lal Fakama for the petitioner appearing in contempt case number 3 of 2014. Other respondents?
Other respondents are there, but then it is the home that we're basically concerned with, because the DC has already done his part.
My lord, we are for the DC.
Mr. So-and-so appears for respondent number
5, 6, and 9 in item number
5, 6 and 9. Mr. B. Lalramenga.
Yes, I'm appearing on behalf of Mr. Bilarameva.
For Mr. So-and-so appearing on behalf of B. Lalramenga for respondent number 5, 6 and 9. And Linda, you are for respondent number 11.
For the Secretary Revenue Department.
I think 11.
Yes.
And 10, there was one advocate on the last occasion.
10, my lordship, your lord, this is my lord. This is the incumbent who had left the office, the previous Home Secretary.
Okay. And Mr. KR is appearing for respondent number
15.
15. In the last order, it is reflected that that Mr. KR would file the power on behalf of respondent number 15, but it is noticed that power has yet not been filed on the ground that he has not received it, right?
Lordship, they have sent through speed post.
He had not received the same from the concerned official. It is as such directed that Mr. KL would file the wakalatnama on behalf of respondent number 15, and it is also directed that on the next occasion, Mr. KL, who appears for the respondent number 15 is the secretary,
Home Secretary.
who appears for the Home Secretary, Ministry of Home Affairs, would place relevant instructions regarding compliance of this court's order dated compliance
Lordship, here
3/3/2011.
direction was from this honorable to
Passed in.
constituted joint verification committee. There was no direction to make payment by this honorable court. Only deputy commissioner, on the basis of a joint verification, he recommended for payment of some document, payment, Lordship. With respect to
Unfortunately, the record says otherwise.
It's okay. I'm just saying you bring the proper instructions. Whatever.
Yes, I have, Lordship may fix a matter, Lordship. I will come physically before this honorable court and place my
That
argument,
will be
Lordship.
better. And
Yes,
because without your wakalatnama, I cannot hear you. So you file
Very well,
your,
madam.
you bring your
Lordship,
proper.
I'll file
If
as
you-
soon as I'll receive, I'll file.
If you say that you are not liable to follow the directions, it is someone else, place that. We will consider.
I will place everything
With
before your
proper
Lordship for
instruction
consideration.
On the next day.
If your Lordship finds at the end of the hearing that the Home Secretary is responsible, Lordship may issue contempt against him. We have no objection, Lordship.
Listed after 3 weeks.
My lord, may I make
On
one
the
small
date.
suggestion?
Ah,
Since
yes.
my learned friend will be traveling from Guwahati, let him propose a date.
What date you can come?
Lordship,
Choose a date
in the
month.
first week of September, 3rd or 4th,
Yeah, choose a date in the month of August. See, it has been lying pending,
In August,
pending for
Lordship,
since so long.
many
2006.
cases, many cases has been fixed in Nagar bench and as well as in principal seat,
You
Lordship.
come on 21st of August.
21st, Lordship, today some matter has been fixed before the division bench of this principal seat, Lordship.
This bench is also equally important. Some priority has to
21st
give
of
it.
August you come. 28.
28, Lordship, matter has been fixed in Itanagar bench, Lordship.
See. Then
Yes,
choose a
Then
Yesterday I was
25th we can do it, my lord.
give a date in the month of August as per your convenience.
And in August, Lordship, I'll appear through VC, Lordship. Any date may be fixed, Lordship.
No, according to your convenience, when you don't have other matters, tell.
Then, Lordship, I want to present physically before this honorable court. Lordship, it's 3rd of September, Lordship.
3rd of September.
Lordship.
Any time in August, can't be so
You
busy
try.
that.
In month of August, Lordship, I'll appear through VC, Lordship. Any date may be fixed by your Lordship.
Okay, let it be by VC only.
Because, Lordship, for
Then,
traveling, as your Lordship, I have to spend 3 days, Lordship.
Then 19th of August.
Very well, madam.
Okay, list it on 19th of August, you come virtually.
Deeply
Both the
obliged.
cases may be fixed together, Lordship.
It's
Both the
already clubbed
cases,
together,
7
madam.
and 3.
Both our cases are tagged together, it is listed together.
Deeply obliged.
Part 2, item number 1.
This is item?
My lord, this is a criminal
We are
appeal.
taking it for final disposal?
Yes, my lord.
Hey, wait, there is one more. Here. This is in respect of Union of India. It was left here. Just see the case, this one. Union of India's appeal. This is this one, item number 6. It will be in item number 6. Yes. Okay. This is what?
My lord, this is part 2, item 1. This is a conviction against
NDPS.
NDPS, section 22C, my lord. And the sentence is for RI for 10 years. And there's also a default clause, my lord.
RI for 10 years. Yes.
With fine.
Miss
And-
Mary, you are appearing? Yes. Yes, sir. RI for 10 years.
My lord, 22C.
Okay.
My lord, before I proceed with the facts, my lord, in
You
the
are Mr.
C. Tan Thiang Lim, I'm for the appellant, my lord.
C. Tandang Lima.
My lord.
Okay. Yes.
My lord, before I proceed with the facts, my lord, in this appeal, I will be pressing my appeal mainly on 5 grounds, my lord. One is that the Malkhana register, wherein the seized articles was kept, was not produced before the learned trial court. And secondly, the safe custody and the whereabouts of the seized articles was never addressed by the learned trial court, because it was seized on 26/10, the seized articles, and it was inventory was done on the next day. And the whereabouts of the seized articles on the night of the 26th and on the night of the 27th was not gone into by the learned trial court.
It was kept in the Malkhana.
It was kept in the Malkhana, but the Malkhana register was not produced, my lord.
Register is not there, but if the police have stated that it was kept in Malkhana, I don't think so there will be any problem with
I will go on into that, my lord, in detail. And the
Okay.
long gap of sending the seized articles to the forensic laboratory, my lord. It took 5 days in this case, because the place of occurrence is Lunglei, which is around 5 to 6 hours drive from Mysore. But it took 5 days from the place of occurrence to
No, from the Malkhana to...
From the Malkhana to the
They
FSA.
have to take it before the the magistrate.
That was done. After inventory was done, it took 5 days to reach the forensic. And my next point will be non-compliance of section 52A as well as 42 of the NDPS.
52A is photographs. And
Photographs
those
and list of samples drawn. That was not done, my lord.
Representative sample.
Yes, my lord. That was not done before the magistrate. No evidence, my lord.
42A and
52A and 42.
42.
42 is
52A and 42. 42 GD entry vagera is made.
42, my lord. The information was written down, but the seizing officer had received the subsequent information, and the subsequent information was not written down and not forwarded to the superior officer, my lord.
It was not forwarded.
It was not forwarded, my lord.
Okay.
I'll start with the FIR, my lord. The complaint. It's page 3 of the paper book. Page 3.
Here I think the paper book is not that properly made, because the 313 statement should go later. First FIR, then
Yes.
charge framing, then the prosecution witness, then 313. Now what I see here is 313
Yes.
is
It
annexed
precedes
at
the evidence.
beginning. That
Yes.
of course. Okay. Then yes, the FIR.
May I read, my lord? To the officer in charge, Nathial Police Station. Sir, on 26/10/2020 at around 11:30 a.m., while I was on duty at Nathial PS, I received a trustworthy information that a wagon R vehicle is carrying some narcotic drugs. This was informed to Nathial Police Station, and the OC issued an authorization letter to us to take legal action as required. My crew and I moved towards AOD petrol pump from the police station, and while we were in and around this precinct, a car bearing registration number MZ01N2644 wagon R silver color was hailed. When we checked the inside of the car, driver Lal Ruat Masonov, so and so Ambeng South, and Lal Zamliana. This Lal Zamliana is the present appellant, my lord.
Lal Ruat Kima is
Lal
not
Ruat
before us.
Kima was acquitted during the trial, my lord.
Oh, acquitted. during
Acquitted,
the
my
trial.
lord. There are two accused, Lal Ruat Kima and Lal Zamliana.
Lal Ruat Kima is the driver.
Lal Ruat Kima is the driver, and Lal Zamliana, the present appellant, is the passenger. Were seated in the front of the car. Lal Zamliana was holding a black rucksack.
Lalzam Lova, he is a different person.
Present appellant, my lord. This may be a clerical error, my
Oh,
lord. It should be
acha.
Lal Zamliana.
So he is the appellant.
Yes,
okay.
present appellant. Was holding a black rucksack in his hand, and we asked him to open this bag and reveal what was inside the bag. He took out a case of Amul Gold, and as we suspect that there is something illegal packed inside, I called the civilian for a witness. When the civilian reached, I made them open the Amul Gold case in the presence of witnesses. There were 2 black polythene packets inside, and I made them open both the black polythene, and inside it there were 2 packets, each wrapped in a yellow color sellotape. Inside the 4 yellow color sellotape, there were packets wrapped in
My
white paper.
God, packets after packets. Packets after
Yes,
packets.
packets after packets, madam.
Okay, then.
Packets wrapped in white paper, and on opening the white paper, a smaller packet of 200
My
numbers
God.
was again
Acha.
discovered. On opening the paper wrapper, black color wrapper of 200 numbers were again found. On opening these packets, we found plenty of red tablets inside. We read the amount of these red tablets in the presence of civilians, and it amounts to 39,000 tablets. On weighing it, the total weight was 4.6 kgs. We have reasons to believe that these tablets are actually methamphetamine, and we therefore decided to seize the vehicle along with the tablets in the presence of civil witnesses. The local market rate of this seized item amounts to rupees 200 per tablet, thus totaling to rupees 78 lakhs. I took the seized item and the owners to Nathial Police Station and submitted a report to the OC. I therefore request you to register a legal case against Lal Ruat Kima and Lal Zamliana for their were in possession of what was suspected to be narcotic drugs. And on the basis of this,
He wrote the, according to the FIR, he gave the information, he took the authorization, then he made the GD entry. Nothing written here. And then he went there, he seized, he
Yes.
found and he seized.
Yes.
And he took the seized items and owners to the station.
yes,
Submitted a written report to the OC.
OC, yes.
Acha. Then, okay. Then,
I'll start with the PW1, my lord. It's
then
a
charge framing is 22C.
charge frame, yes, 22C, my lord. Charge frame at page 5. Charge was framed to which they pleaded not guilty and claimed for trial, my lord.
Only 22C.
Yes.
And this one not required, he is acquitted. Then, yes. Or then 313, okay, skip it.
Page 11.
Page 11.
This is the evidence of the complainant, my lord. I know both accused who are present in the court today. On 26/10/2020 at around 11:30 am, I was at Nathial Police Station on duty. I received an information through mobile phone that one vehicle is about to take contraband articles from Nathial town, and accordingly I record the information and report the matter to OC Nathial Police
So he
Station.
recorded the
He
information.
recorded the first information, madam. He is going to
First
receive
information.
subsequent information, madam. Here I also
that is a requirement under 42.
pardon, my lord.
That is a requirement under 42.
Yes, my lord.
Because on receipt of the information, secret info, he has to immediately write down in the general diary.
That's true. That's true.
That is what he did, and he reported the matter to OC.
Yes, yes,
Okay.
that's true. Here I also record the matters in GD number so and so dated 26/10/2020. Authorization was issued by OC in my favor, and accordingly me and my party performed duty at 3 different places, namely Lunglei Road, Sersib Road and Thingsai Road. After outing for duty, I received another call. This is which I would like to stress, my lord. After outing for duty, I received another call from the same informer that the suspected vehicle is Wagon R bearing registration number MZ01N2644, and I noted down the registration number and informed the same to all the 3 duty points. After about 10 minutes, the duty on CRC brought near AOD Natil report to me that they detained the suspected vehicle, and on knowing this, I immediately rushed to the duty point. On reaching the place of occurrence, I saw the suspected vehicle parked on the roadside of National Highway, where the present 2 accused were sitting on the front seat inside the car. Here the accused Lal Zamliana put a bag rucksack on the floor of the car between his legs, and as we suspect the said rucksack contained contraband articles, I called witnesses from the neighboring area. Within a minute, some witnesses arrived on the spot, and in presence of witnesses, I told both the accused to get out from the car with the rucksack. Then on the roadside, I asked the accused to open the rucksack, and on opening of the rucksack, there is a Amul gold case, and they opened the Amul gold case again, and inside it there was 2 black polythene, and inside black polythene there was 4 package which was covered with yellow tape. On opening the 4th package, there was 20 small package wrapped with white paper again, and opening the small 20 package, there was 200 small pack covered with black polythene, and opening the said 200 small package, there was 39,000 tablets of suspected contraband drugs. On the spot, the said 39,000 tablets of suspected contraband drugs was weighed, and it was measured 4.6 kgs. Here, in the presence of witnesses, the seized articles were counted, weighed, sealed, and packed was done at the place of occurrence. I prepared seizure
and it
memo.
was done at the place of occurrence?
Yes, ma'am.
Weighing, sealing, packing means simply packed?
Yes, I believe so.
Not taking sample and all, right?
Yes, yes.
Acha.
I prepared seizure memo on the spot in respect of the suspected drugs and vehicle bearing registration number so and so used for transporting the said suspected contraband drugs, and obtained the signature of 2 witnesses on it. Other than this, we do not conduct body search upon the 2 accused and searching of another suspected article over the said vehicle. I produced the 2 accused with seized articles before Natir Police Station, and I submitted inquiry report to OC Natir Police Station. Here we have exhibited the information recorded and so and so, madam.
Authorization,
Yes.
seizure memo, inquiry report, arrest report, seizure index, Jimmanama. Okay.
Yes, and it's a cross-examination. I remember that the time I received information, which is 11:30 a.m. I denied that I do not record information I received. It is a fact that I do not record grounds of belief. It is a fact that I received information to conduct search, and the authorization is valid only up to 27/10/2020. I denied that I do not report information I received to OC Natil Police Station. I denied that at the time of searching, accused Larwat Kima was not present. I do not conduct search on the vehicle. It is a fact that I do not conduct search over the body of both accused. It is a fact that I prepare seizure memo on the place of occurrence, but I do not remember the exact time. It may be in between 12 noon to 1 p.m. It is a fact that at the time of search there are 2 independent witnesses. It is a fact that packing, sealing, marking of seized articles were done in the presence of witnesses on the spot. Other than the rucksack kept on the car floor in between accused Lal Zamliana's leg, I did not conduct search over the body of 2 accused and vehicles. I complete seizure in the case before 2:50 p.m. on the same day. Then re-examination by the additional PP. Regarding validity of authorization, even if authorization is not valid, I am authorized to conduct search without authorization in this instant case, as the place of occurrence is public place. Regarding bodily search, even I do not conduct body search over the 2 accused. I mistakenly prepare grounds of belief under Section 50 of NDPS Act. Then further cross-examination. I deny that I prepared seizure and arrest memo and other enclosed document without knowing the facts. And the next witness is PW2. This is the seizure witness, my lord. I have
Earlier one was the complainant.
Complainant, my lord.
And this is regular appeal, right?
Yes.
Not amicus.
Yes, regular.
PW2.
PW2, my lord, I'm not disputing any of his depositions, my lord. So, PW3 is also the seizure witness, my lord.
Okay. What he had said? Pandemic?
Yes.
Acha, acha. At around so and so and Wagoner coming towards Aizawl from Sai, we stopped
Yes.
there. Okay.
My only contention in the deposition of PW2 and PW3 was that they have stopped their vehicle. but they are not officers and as mentioned in section 42 of NDPS, so they have no authority to stop the vehicle. That is my only dispute in their evidence, my lord.
They don't have the authority
They
to
don't
stop
have authority to stop the vehicle, my lord.
So how did they stop the vehicle?
At para 2, my lord, page 14,
This is PW2, huh? Yes.
PW2, para 2, my lord.
During incident?
During incident, I was the vice chairman of VLTF Nathial Electric Bank. The incident happened during total lockdown during COVID-19 pandemic. On 26/10/2020, we were performing duty as VLTF.
We were
This-
performing duty,
This means a village level task force. For-
village level task force. Village level task force.
Yes. Near
They
a
stopped the vehicle because pandemic, the vehicles were not allowed to ply. Because of that, they stopped.
that is what they have said. But my lord, in the during this period, there was no restrictions on travel of vehicle, my
Why
lord.
October 20?
Yes.
October 20
It was during the
there
pandemic.
I think. Huh?
It was during the pandemic.
During the pandemic?
Yes.
And the vehicles were not allowed.
My lord, but in the
We tried to inform the matter and so arrived and okay. But during this time pandemic was on, the restrictions were on. And so they stopped. They were from village
there was
level
some restrictions, but there is no need for obtaining permission for travel within the state, my lord, during this time, because the state government have issued certain regulations with respect to the travel and all. But during this incident, my lord, there is no restrictions within the state.
Oh, within the state of Aizawl,
Mizoram, yes,
Mizoram.
yes, yes,
Otherwise in Guwahati it was.
yes, yes. It differs from state to state and from district to
Okay.
district.
So according to you, their statements are only to that extent.
Only
right?
to that extent. I'm
Okay, then
and at page 19, this is the evidence of the case IO, my lord.
19.
Yes.
PW 4, 5. So 3 and 4 are same.
3 and 4 are the same, my lord.
Okay. 5.
PW 5. I know both the accused who are present in the court today.
He's what?
He's the case IO.
Oh, he is the IO.
Yes.
Yeah.
At the relevant time, I was posted at officer in charge at Nathial Police Station. On 26/10/2020 at 2:40 p.m., SI Elish Ram Thanzwala seized 4.6 kgs of methamphetamine at Nathial near AOD. In this connection, he submitted inquiry report to Nathial PS and Nathial PS case number so and so dated 26/10/2020 under section 22C was registered. He also produced accused Lal Zamliana and Lal Rotkima at Nathial PS along with seized articles. Seized articles were kept in Nathial Police Malkhana White registration number 11/20 and I investigated the case.
So it was placed in.
It was kept in the Malkhana as per the case I have. During investigation, I interrogated both accused. Accused Lal Zamliana admitted his guilt and stated that he came to Nathial by using wagon R driven by accused Lal Rotkima to collect the contraband drugs from Sangkui. He further stated that he promised to pay rupees 15,000 to driver Lal Rotkima for hiring. I recorded his statement. I also interrogated accused Lal Rotkima and he stated that accused Lal Zamliana hired his vehicle for rupees 15,000 from Aizawl to Nathial. He denied the ownership of the seized articles and I also recorded his statement. Even though he denied the knowledge and ownership of the seized articles, my investigation revealed that the hire rate at the time was only rupees 7,000, which is much lesser than their hiring rate. As such, I strongly suspected accused Lal Rotkima to have involvement in this instant case. Further, my investigation revealed that Lal Zamlian and Lal Rotkima are brother-in-laws, and which make me more suspicious, as being brother-in-law they may come without giving hiring charge. Hence, I arrested both accused persons at Nathial PS and arrest intimation was given to their relatives. I sent both the accused persons for medical examination and received their report. On 27/10/2020, I submitted application for inventory of seized article and prepared inventory before JMFC. Drawing of sample packing and sealing of the seized article was also done before before magistrate in presence of accused persons. I also submitted prayer for judicial remand. I sent the sample to FSL and received the report which proved that the seized article was methamphetamine. From the light of investigation, a prima facie.
52A. The compliance of 52A.
This is what he has stated in his evidence, my lord. From the light of investigation, a prima facie case under Section 22C of NDPS Act 1985 against both the accused persons, and I charged them accordingly. I then submitted charge sheet before the court. And exhibit
Those permissions were given, right, by the
permissions were
magistrate?
given, my lord. But I will come to that later, my lord. Exhibit P16 is the inventory, and I will mention only the important exhibit, my lord.
Inventory,
Exhibit P16.
arrest memo, medical examination, medical reports, application for inventory, then signature of JMFC, okay.
Yes.
Drawing of samples, forwarding for FSL, certificate, FSL report, arrest memo, okay, charge sheet.
Yes, it's there. And it's a cross-examination. At the time of incident, I was OC at Nathia Police Station. In this instant case, my subordinate submits information recorded to me, but I do not remember the exact time. I take up the case by myself to investigate, as there are no other competent officers to take up the case in our station at that time. I was not present at the time of seizing, but later I visited the place of occurrence for being case IO. From my investigation, I learned that seized articles were recovered from a vehicle, while one of the accused, Zambian, holding the bag contained seized article. I thought the vehicle was searched, and a ground of belief was also prepared at the time of seizing. It is a fact that seized article was not recovered from the physical possession of Lerwat Kima. I do not know the exact time of seizing, but it was around 2 p.m. I do not know whether body search was conducted over the two accused. I do not know the numbers of small packets inside the seized bag, but I know the total number of tablets, which are 39,000 tablets. It is a fact that there was no civilian witness at the time of sample drawn before magistrate. I do not remember how many tablets were separated from each packet and sent to FSL. I still remember that sample was sent to FSL on 29/10/2020, but I do...
29/10.
Yes. Seizure
And
was
recovered was 26.
26. And
27, 28, 29.
inventory was done on 27.
27.
It was sent to FSL on 29.
It should have been on 28.
Yes,
but
and
1 day delay.
it was received by the FSL after 5 days.
Received after 5 days.
Yes.
After 5 days of 29.
Yes, yes.
Acha. Prepare?
I prepare inventory for drawing sample. I record the statement of two accused, but recording of witness statement was done by seizing officer. The statement of two accused were recorded without inducement or threat, and as per what they stated only. As per his statement, Lerwat Kima stated that he has no knowledge in this instant case. Other than the rate of hiring, which is higher than normal rate, and being brother-in-law, the hiring charge is expected to be lower than normal rate. I have no other evidence to book accused Lerwat Kima under the charge section. It is a fact that I do not have any document to show before the court the normal rate of hiring from Aizawl to Nathial at that time. At the time of incident, road widening was stated at some place between Aizawl to Nathial. However, at that time, rate of sumo was still the same, but I do not know hiring charge of vehicle was increased or not due to widening of road. I do not remember the exact time, but it was 26/10/2020 when I gave authorization to SI LH Ram Tanzola, and the authorization is valid for 1 day. I do not remember the day I received report from FSL. Re-examination. Regarding cross-examination number 21, even though I state that authorization was for 1 day, I mean to say that the authorization issued on 26/10/2020 will be valid from 26/10/2020 till 27/10/2020. Then comes the evidence
That's
of the...
all.
That's all,
That's all for the
from the
PE,
prosecution, madam. Yes.
So only the IO and the complainant
Yes.
and
Two seizure witnesses.
Seizure witnesses.
Yes.
Those are 3 and 4. 3 and 4 are those village people who had stopped the vehicle.
2 and 3. PW 2 and 3.
3 and 4. 3 and 4 are those task force persons.
As per the paper book, my lord, PW1 is the complainant, and PW2 and 3 are the seizure witnesses, and case IO is PW5.
Acha, 2 and 3 only. Okay. 1 is the complainant.
Complainant.
2 is 2 is that village task force.
Yes, 2 and 3 are village task force.
And
PW, the original PW4 was dropped, who is the assistant director of FSL.
Acha.
He was not examined as a witness. He was named in the charge sheet, but he was not examined. He was dropped.
Whether that will be fatal?
It may be fatal, my lord.
Acha, there is no 4, right?
There is no 4, yes.
Okay, 2 and 3.
PW1, PW2, PW3, and PW5.
Perhaps 4 was the scientific officer?
Yes, yes, Assistant Director FSL. He was named in the charge sheet, but he was not examined, my lord.
Any reasons?
I-
Perhaps
I-
it will be there in the
Yes,
order
it may
sheet.
be in the case record, my
Order
lord.
sheet will be
Yes.
there. Okay, we'll go through that.
I will not go into the defense witnesses, my lord, because the defense witnesses doesn't help much to the instant appellant, my lord. It's mainly regarding the hiring charge and all.
Oh, in respect of the
In
other
respect of the
accused.
hiring only, yes, my lord. And the impugned judgment, my
Of
lord.
course, something will be important that the appellant had hired the vehicle on that day.
Yes.
To that extent. it
To
will
that
be-
extent only, my lord. It's not it's an admitted fact that the vehicle was hired, my lord. And that is why the accused number 1, the driver, was acquitted.
Okay, then
The impugned judgment and order is at page 42, my lord.
impugned judgment not required to be.
Okay.
Then you go through.
Shall I read the operative portion, my lord?
Only a short operative portion.
From page 61, my lord.
61.
Yes.
That will be too long. Read the findings and the findings, right?
Yes, findings and
You
reasons.
read the question and the answer in between. Don't have to see what is important. Page number 61. Any procedural irregularity?
I have raised a procedural irregularity, my lord, but the learned trial court had find that there is no irregularities committed by the investigation, my lord.
Okay.
And at page 67, my lord, this is regarding whether the seized 4.6 kg of methamphetamine was recovered from the possession of the accused persons, my lord.
Again, conscious possessions, constructive
Yes.
possession, those
Yes.
will come.
Yes.
Okay. Then,
At page 73, my lord, the learned trial court had concluded that the prosecution had proved their case beyond reasonable doubt against the present appellant, and he was convicted under section 22C. However, the other co-accused was
he is
acquitted.
hereby acquitted. Charges.
Yes.
He is said, however, accused so and so is convicted.
Yes.
Then tell me your case.
My lord, I have prepared, my lord, my submissions in GIS, my lord, so if I may be allowed to furnish. My lord, first point is regarding the failure to produce the Malkhana register, my lord. As per the evidence of the case IOP W5, my lord, he clearly stated that the seized articles was kept in the police station Malkhana. But the Malkhana register, it was not produced before the learned trial court, my lord. So the chances of tampering the seized articles cannot be ruled out in this case, my lord. And whether they were in safe custody or not, also that has not been gone into by the learned trial court, my lord. And second is the failure to consider the safe custody and the whereabouts of the seized articles, my lord.
Okay.
As I have stated, my lord, the seizure was made on 26/10, and
Acha,
inventory.
you have relied on 2 judgments for this Malkhana register.
Yes, yes.
Show me those.
This is 2024-5 SCC 393 and 2005-3 SCC 59. I'll read this 2024 first, my lord. Mohammed Khalid and another versus State of Telangana. 2024 5 SCC 393. Relevant portion is at para 22 to 25. Shall I read, my lord?
Here also, register was not produced.
Not produced, yes, my lord. Sub-Inspector so-and-so who prepared 3 samples of ganja as per the testimony of PW5 was not examined in evidence. In addition thereto, the prosecution neither examined any witness nor produced any document to satisfy the court regarding safekeeping of the samples right from the time of the seizure till the same reached the FSL. The official who collected the samples from the police station and carried the same to the FSL was not examined at the trial. From the quoted portion of the evidence of seizure officer...
Go slow, go slow. The official who collected the samples from
the police station and carried the same to the FSL was not examined.
Otherwise, the sampling will be done before the magistrate.
That I will address that later, my lord. Here also in my...
Here, of course, it is done.
It's done, but here also, my lord, the official who collected the samples from the police station and carried the same to the FSL was not examined at the trial. Here also, in my case also, my lord, the officer who had delivered the seized articles to the FSL was not examined, my lord. He's a vital witness, my lord. From the quoted portion of the evidence of seizing officer, it is clear as daylight that he handed over one of the 3 samples to the accused. The witness also admitted that he did not mention about sealing of the samples in the punch number. Contrary to the evidence of PW1, PW5 stated that 3 samples of ganja were taken out by Sub-Inspector so-and-so and were handed over to the witness who forwarded the same to the SCP for sending it to FSL. In cross-examination, the witness admitted that he did not file any document to show that the property was kept in Malkhana. The Malkhana register was not produced in the court. The FSL report does not disclose about...
This is in addition to the fact. This is in addition to the fact that it was not kept in the Malkhana. In cross-examination, witness admitted he did not file any document to show that property was kept in Malkhana. Even the fact that the property was kept in Malkhana was in doubt here. But in our case, it was kept in Malkhana as stated by the police.
The police have stated...
And further, Malkhana register was not produced.
Yes, the case I have only stated. But it is his duty to produce the Malkhana register in the court also, my lord. And
but there is little difference between this case and this.
There is no difference, my lord, because in my case also, the case I have only stated that it was kept in the Malkhana register.
At least that is there. Here, that was also not there.
Yes, yes.
Then, the FSL
Para 24, my lord. The FSL report does not disclose about the punch stitch and the seals and signature of the accused on samples. The property deposited in the court was not having any official seals. The witness also admitted that he did not take any permission from the court for changing the original 3 packets of Mudalgam ganja to 7 new bags for safekeeping. These glaring loopholes in the prosecution case give rise to an inescapable inference that the prosecution has miserably failed to prove the required link evidence to satisfy the court regarding the safe custody of the sample packets from the time of the seizure till the same reached the FSL. Rather, the very possibility of 3 samples being sent to FSL is negated by the fact that the seizure officer handed over one of the 3 collected samples to the accused. Thus, there remained only 2 samples where the 3 samples reached the FSL. This discrepancy completely shatters the prosecution case. And the other judgment is, my lord, 2005 3 SCC 59. This is a State of Rajasthan versus Gurmel Singh, my lord. Relevant portion is at Para 3. We have perused the judgment of the High Court. Apart from other reasons recorded by the High Court, we find that the link evidence adduced by the prosecution was not at all satisfactory. In the first instance, though the seized articles are said to have been kept in the Malkhana on 25/1995, the Malkhana register was not produced to prove that it was so kept in the Malkhana till it was taken over by PW6 on 5/6/1995.
Achha, this covers your case.
Yes,
so
yes, exactly, my lord.
Yes.
The facts are exactly same, my lord. We further find that no sample of the seal was sent along with the sample to the excise laboratory in Jodhpur for the purpose of comparing with the seal appearing on the sample bottles. Therefore, there is no evidence to prove satisfactorily that the seals found were in fact the same seals as were put on the sample bottles immediately after seizure of the contraband. These loopholes in the prosecution case have led the High Court to acquit the respondent. Here, my lord, in my case also, even though the case IO have stated that the these articles were kept in the Malkhana, but the Malkhana register was not produced, my lord. And my second ground is that, my lord, the safe custody and the whereabouts of the seized articles was not gone into by the learned trial court. And the long gap and the failure to produce the vital witness who had actually delivered the seized articles to the FSL, he was never named as a prosecution witness, my lord.
So you are questioning the seized articles after it was brought to the police station kept in Malkhana?
Yes.
After that there is nothing?
After that, there is nothing, my lord.
So after 5 days it was, but immediately on the next day it was produced before the magistrate.
Seizure was made on the 26th. Inventory was done on the 27th. It was sent to the FSL on the 29th. And the whereabouts of the seized article on the 26th, on the night of the 26th, and on the night of the 27th, and on the whole day of the 28th and the 29th, there is no explanation at all, my lord.
Wait, let me write it. This you have not elaborated here. So night of 26, 27?
27 inventory was done. And on the night of the 27th, and the whole day of the 28th and the night of the 28th. There is no explanation at all about the whereabouts of the seized articles, my lord.
Then 29?
29th it was sent to the FSL.
So there is no explanation as to...
No explanation, my lord.
Then?
If you will see at, my lord, page...
long gap and failure.
yes. Page 124 of the paper book.
124.
Yes. This is the forwarding made by the case IO to the FSL. Here you
This
can...
was on 29th.
Yes, it was sent to the FSL on the 29th.
Which expert? Okay. This is FSL.
Yes.
Sending it to FSL.
That was on 29th. But if you will see at page 130, my lord. 130.
Yes. This is?
This is the acknowledgement receipt of the FSL.
Okay.
If you will see the date of receipt,
29.
at serial number 4, that date of receipt is 3/11/2020. At
Date
12.
of receipt is 3/11.
Yes, at 12:30 p.m. So, my lord, my submission is that the
FSL is Mizoram.
Aizawl.
The laboratory is where?
Aizawl, here in Aizawl.
And why did it take so many days to reach?
Exactly, my lord, exactly. There is no explanation at all, my lord.
It was brought by special
messenger, my lord. It was brought by special messenger by this head constable Lalram Moya. The name is also there. But this
Where the name is?
mode of receipt
Huh?
at serial number 3, my lord. Mode of receipt, special messenger, name Lalram Moya.
Where? Which page?
In page 130.
130.
Yes, in the acknowledgement receipt itself.
Name of special messenger.
Yes.
Signature.
Yes.
Where is the name?
Just next to mode of receipt, my lord. Name Lalram Moya is there.
Oh yes. Mode of receipt. Special messenger. Lalrum Moya.
Yes. He's a head constable.
That of course is a problem.
Yes, my lord.
29, 10 to 3/11.
There's a gap of 5 days, my lord. And the Nathial, where the alleged offense took place, is only about 5 to 6 hours drive from Aizawl.
Wait. Acha, not very far also, right?
Yes.
So it was 3/11/2020.
Yes.
Then?
So there was no explanation at all who was in possession of the seized articles during these 5 days, and this head constable Lalram Moy, who had delivered the SA through the special messenger, was also not examined as a witness, my lord. So, my lord, the safekeeping and the whereabouts and the days...
Special messenger also not examined?
Yes, not examined. The whereabouts, the safe custody and the long gap of the seized articles to reach the FSL was also, there was no explanation at all, my lord. So it creates doubts on the case of the prosecution, my lord. And in this connection, my lord, I would like to rely on the...
Bhimram.
Yes, Bhimram. 2012 1 GLT 416. Mm. 2012 1 GLT 416. Relevant portion is at para 9, from para 9. Shall I read, madam?
Yes.
From records, it is found that all the three accused persons, along with the child, were produced before the learned CJM Barpeta on 19/12/06. It is found from the deposition of PW5 that he sent the seizure list for perusal of the learned CJM without producing the seized articles. In the meantime, the samples of the seized ganja were sent to the FSL by a special messenger on 19/12/06 for examination and report. As per the evidence of IO PW5, he sent the samples to FSL for examination and report by a special messenger on 19/12/06, but due to holiday it was received on 21/12/06. There is nothing on record that the samples of seized articles were drawn, packaged and sealed without due permission from the learned CJM or any magistrate. Nothing is found on record how the IO of the police outpost, who himself was the IO, could keep the seized ganja and the packets of sample thereon in the police outpost till the same was sent to the FSL. If it is to be accepted that the samples sent by him were received by the FSL on 21/12/06, the IO has to explain as to under whose custody the samples were kept in the night of 19/12/06 and the whole day and night of 20/12/06. The special messenger who carried the samples to FSL was not examined by the prosecution to give evidence to the effect that the samples were handed over to a responsible official of the FSL to ensure safe custody thereof. It is not proof whether the sample packets of the seized articles were sent to the FSL on 19/12/06. What did the special messenger do when he could not deliver the sample packets of the seized articles to FSL on 19/12/06 at Guwahati? If he could not deliver, whether he stayed back at Guwahati with the sample packets or whether he returned to Barpeta Road and handed over the sample packets back to in charge PW5. It may happen that the special messenger did not return to Barpeta Road on 19/12/06 and he might have stayed back at Guwahati till reopening of the office on 21/12/2006. It was quite risky and impermissible to leave the samples with the special messenger for a long gap. For lack of evidence, it is not possible to take a definite view on the safe custody of the sample packets at the hands of the special messenger, but one thing is clear, that the in charge of the case took no measure to ensure safe custody of the sample packets till the same were received by the FSL. The whole process of sending the sample packets to FSL does not ensure protection against possibility of being tampered with. And I will skip some paragraphs, and that paragraph 14, madam. Paragraph 14.
Yes.
The evidence adduced by the prosecution is not only insufficient but also far from satisfaction for recording conviction against the accused under the NDPS Act, which provide more stringent provision for conviction. This principle of law is that more stringent the provision of conviction, more rigorous investigation and trial is necessary. Looking at the manner in which the investigation was conducted and the procedure followed by the IO in sending the samples of seized articles for chemical examination, there is no doubt that no such rigorous investigation has been made. Rather, it is found to be full of loopholes. The basic requirement is that the samples packet received by the FSL authority are the same to the contraband articles recovered and seized from the convict appellants at the railway platform. In the instant case, it is not proved beyond reasonable doubt on the face of the admitted position that the seized articles were kept in police outpost from 18/12/06 till the same were sent to FSL on 19/12/2006 without any order from the court or higher authority. The prosecution, in my considered view, could not establish its case against the appellants beyond reasonable doubt, and under such circumstances, the appellants are entitled to get the benefit of doubt and acquittal herein. And another judgment is 2019 5 GLT. This is also a judgment of a coordinate bench of this honorable court. This is also regarding safe custody, my lord. 2019 5 GLT 828. Relevant portion is at para 19. Shall I read, madam? Coming to the next point raised by the learned counsel for the appellants, it can be seen from the requisition slip or test memo sent by the officer in charge of the police station concerned on 4/8/2017 to the director of Forensic Science Laboratory that samples from all the 21 packets were drawn and their approximate weight was 1.4 grams each. The samples then reached the Forensic Science Laboratory on 7/8/2017, and from the report prepared by the Assistant Director of the FSL, the samples were found to be having the weight of 357 milligrams to 615 milligrams. Not only this color, the color of the samples drawn as per the test memo were described as light brown powder, while it was described as yellowish powder by the Forensic Science Laboratory. Although the description of the color may not be the most crucial point to be determined as submitted by the learned PP, but the discrepancies in the weight of the samples will make a lot of difference and cannot be overlooked. This court in Bimram and others Supra has held that it would be risky and impermissible to leave the samples with a special messenger for a long gap of time. Chances of tampering when there is lack of evidence about the safe custody of the sample packets in the hands of the special messenger cannot rule out. The provisions of NDPS Act provide for stringent provisions of conviction. Therefore, the principle of law is that the more stringent the provision for conviction, the more rigorous will be the investigation and trial. In the given facts and circumstances of that case, court was of the view that the prosecution failed to prove the case against the appellants with proof beyond reasonable doubt, and as such acquitted the appellants by giving them the benefit of doubt. Likewise, in the case of Lalruat Pui Boitlung Supra, this court, upon finding there were discrepancies in the samples drawn for examination by the Forensic Science Laboratory, more particularly on the weighment of the seized articles, found the accused appellant entitled to be given the benefit of doubt and accordingly allowed the appeal of the accused appellant by acquitting her from the charge.
But here, of course, the weight
Yes,
change and the
yes,
color.
yes. But I would like to
But
stress.
again, long gap.
Yes, long gap. In Bimram also, it's regarding the long gap.
This is risky.
Yes, yes. And my next point is regarding non-compliance of Section 52A, madam.
No photographs were taken?
No
while
photographs were
inventory was-
taken, no list of samples drawn were made, madam. If you will see at page 121, madam, of the paper book. This is the application for application to the magistrate, my lord, for compliance of Section 52A. It was made on 27/10/2020. And at the next page, my lord, am I going too fast, my lord?
The prayers were certify the correctness, permit taking photographs
Yes,
in your presence.
yes. And certify such photographs as true.
Allowing taking representative samples.
Yes,
And
and certify
certify
the correctness of
So
list
these
of
are not
samples.
done.
Only A was done, my lord. Certify the correctness of the inventory. There were 3 prayers made as per the Section 52A, but only 1 was complied, my lord.
Where do I find it?
At page 122. This is the correctness of the inventory, my lord. It was certified by the learned magistrate at the bottom, my lord. 3 prayers were made as per Section 52A, but only this part is complied. Only A is complied, my lord.
No, see the certificate at the bottom of page 121.
Yes, yes,
Allow the certificate by magistrate.
yes.
Allow the above application under remand of the narcotic drugs and hereby certify the correctness of the inventory, the enclosed photographs taken and a list of samples drawn in my presence. So as if the all things are done.
Yes, but if you will
This
see,
is a certificate by the magistrate.
no, but this is, I think this is the format only, because, my lord, there's no signature of the magistrate here. At page 122, my lord. This is the inventory, correctness of the inventory. Here the magistrate had certified, my lord, with his signature, my lord. This at the bottom.
Whereas the above officer applied to me also to certify the above inventory and subsection 3 of this requires any allow the application having satisfied the above inventory is as per seizure documents and consignment of seized
This
goods
is
presented to me certify the correctness of the
with regard to the inventory only, my lord. But photographs taken and this list of sample drawn, there is nothing on record, my lord. three prayers were made in the application. One is for correctness of the inventory, second is for photographs, third is for list of samples drawn. But only the first prayer is complied with, my lord. This is to certify the inventory, my lord. Above else, nothing is on record, my lord. No evidence were left. And in support of my submission, my lord,
Majem Ali.
yes, Maniru Jaman, Criminal Appeal 392 of 2023, my lord. This is a judgment rendered by a coordinate bench of this court, my lord.
It is already one. We'll come back at 2 then. Majem Ali, let's see Majem Ali once. Paragraph 26 to 31. Okay, we'll see it at 2.
Yes.
How long will you take? Only this?
Another 30 minutes.
Then you will reply. Okay, at 2 then.
Yes, madam.
Tại tôi tè cái tên này.
Ah,
Anh có chút suy nghĩ nào bắt lòng nó. Kami at the
Yes, thank you.
so, my lord, what I
think
was
the
saying,
Government Council has some problem in
Yes.
replying today.
yes,
So you finish your argument, she
Yes.
will reply perhaps day after tomorrow.
yes, yes, she has informed me.
Ah, she has
Yes.
informed my thing. Okay.
So, what I was saying was that the non-compliance of section 52A.
Huh. You were on that.
Yes, I was on that.
Wait, let me take your. Yes, 52A.
Yes. Here, my
Oh,
lord.
you are showing Majem Ali?
Yes. No, this Manura Jaman, Criminal Appeal 392 of 23.
Which one?
Maniru Jaman, Criminal
No,
Appeal.
you were showing this one. Majem Ali it was not over when I had left.
Oh, I see.
Majem Ali is
Majum
where?
Ali is 2024 5 GLT 635.
24/5 GLT. I was holding that only. Majem Ali.
It may be in the book, my lord.
It is in the book.
Yes, yes. 2024 5 GLT, yes.
No, but then I think, is it in the book? I was seeing the book.
635, yes.
Did you give a printed copy?
No,
Printout?
with regard to Majum Ali, I rely on the book.
Acha. Okay.
Relevant portion is from para 26, madam, page 644,
Paragraph 26.
page number 644.
Huh. Yes.
May I read, madam? Though PW4 proved the application filed before the jurisdictional magistrate under subsection 2 of section 52A, and though he has exhibited the certification under section 52A, subsection 3 issued by the judicial magistrate first class certifying the inventory to be true, however, there was no certification as regards the photograph of the samples and as regard taking of samples as mandated under section 52A. There is no certification in any form or in any manner by the magistrate that the photographs of the seized contraband exhibited were taken in presence of magistrate, nor there is any certification that such photographs by the magistrate are true, except putting a sentence on the photograph certified to be true. In the considered opinion of this court, such certification in the aforesaid manner shall not give the photographs the value of a primary evidence, more particularly to prove that photographs were taken before the magistrate. There is also no certification that the representative samples were taken in presence of the magistrate and that the list of samples is correct. Thus, the prosecution has not only failed to produce primary evidence in terms of section 114G of the Act 1872, but has also failed to adduce secondary evidence in terms of section 52A, subsection A of the Act 1985. The certificate of the magistrate is exhibited as Exhibit P11. However, such certificate is not in terms of the mandate of the provision prescribed.
The magistrate certified that the inventory is as per the seizure document and the consignments of the seized goods related to the case, and the inventory is correct. However, what is mandated under law and as recorded herein above is not only the correctness of inventory so prepared, but also certification that the photographs of such contrabands was taken before the magistrate, and such photographs are true, and that the samples were drawn in presence of the magistrate and the samples are correct. However, as recorded herein above, except a certificate of inventory is correct, nothing is there. Therefore, in the considered opinion of this court, there was no evidence to establish that it is the representative sample of the contraband seized and that it is the true photograph of such sample taken before the magistrate. So, my lord,
I think there are judgments saying 52A is what? Not mandatory. It is procedural. It is what? It is not mandatory.
it is mandatory, my lord, as per my limited knowledge, my lord.
Achha.
And here in my case, my lord, the inventory was done. Certificate is also there. To that part only,
But photographs and the inventory
photographs and the
samples,
list of samples was never done, my lord.
representative sample and photographs were not there.
Yes, my lord.
No certification.
No certification, my lord.
Achha.
And another judgment, my lord, is Criminal Appeal number 392 of 2023. Manijud Jaman. This is also a judgment rendered by the coordinate bench of this honorable court, my lord.
This is non-production of Malkhana register.
And
This is on
52A, 52A is also there, my lord,
Also
from
there.
paragraph 50, my lord.
Is it there?
Yes, my lord.
It is here only.
I have provided a printed copy, my lord.
Acha, you have annexed it with it? Oh, acha, acha. Okay.
Yes.
Manizud Jaman.
Yes.
Mm.
This is also judgment of this honorable high court, my lord. Paragraph 50, my lord. Page 23. May I
Page
read, my lord?
23.
Page 23. Paragraph 50.
50.
In the instant case, it was required that after drawing of representative samples, a list of such samples should have been prepared containing such details relating to its description, quality, quantity, mode of packing, batch number, or other such identifying particulars of the sample drawn, and thereafter the correctness of the list of samples so drawn should have been certified by the magistrate. However, in the instant case, it appears that no list of representative samples drawn was prepared, hence certification regarding the correctness of the same by the magistrate does not arise. This seems to be a violation of the mandatory procedural requirement as envisaged by Section 52A of NDPS Act
Mandatory
1985.
procedural
Yes.
requirement.
Yes. This court is of considered opinion that as the apex court has observed in a catena of its rulings that the compliance with the procedural requirement of Section 52A of the NDPS Act 1985 is mandatory in nature, and any non-compliance would create serious doubt about the veracity of the prosecution case. Hence, in the instant case also, this court is of considered opinion that due to non-compliance of the mandatory procedural requirement of Section 52A of the NDPS Act 1985, the prosecution side has failed to prove the guilt of the appellant beyond all reasonable doubt. Accordingly, the conviction of the appellant under Section 21C of the NDPS Act 1985 in the considered opinion of this court is unsustainable, therefore the same is liable to be set aside. So, my lord, in paragraphs 52 to 55 in this judgment, it also speaks about the Malkhana register, my lord. Shall I proceed, my lord?
Yes, yes.
Paragraph 52. There also appears to be force in the submissions of learned counsel for the appellant that chain of custody was not maintained while sending the samples after its withdrawal from the contraband till it reached the forensic laboratory for its examination. It appears that though the PW6 has deposed that the contraband was kept in police station Malkhana, however, apart from oral testimony, nothing was produced to substantiate this evidence. No Malkhana register was produced to show that the samples which were drawn from the contraband were kept in Malkhana before it could be sent to the forensic laboratory for its examination. We have seen that no list of samples was prepared in this case. Another disturbing aspect in this case is that though the inventory was certified by the learned magistrate, however, on perusal of the said inventory, it appears that same was not prepared conforming to the requirements as mandated under Section 52A of the NDPS Act. It is provided in Section 52A of the NDPS Act that the concerned officer shall prepare an inventory of such narcotic drugs, psychotropic substances, controlled substances, or conveyances containing such details relating to their description, quality, quantity, mode of packing,
marks, number, or such other identifying particulars of the narcotic drugs, psychotropic substances, controlled substances, or conveyances, or the packing in which they are packed, country of origin, and other particulars as the officer referred to in subsection 1 may consider relevant to the identity of the narcotic drugs, psychotropic substances, controlled substances, or conveyances in any proceedings under this Act. However, in the instant case, the inventory mentioned only about the name of the seized cough syrup, that is S-cough, and no other details relating to its description like mode of packing, marks, numbers, or such other identifying particulars of the contraband or the packing in which it was packed, country of origin, or other particulars has been mentioned in the inventory. Moreover, in the absence of a list of samples, there is nothing on record to show that the sample examined by the forensic laboratory was drawn from the lot of 13 cough syrup bottles which were alleged to have been seized from the house of the appellant. The penal provisions of the NDPS Act prescribes very harsh punishment for the offender. Therefore, it is incumbent for the prosecution side that the mandatory procedural requirement to be followed by the prosecution in such a case are to be strictly followed. Any lapse on that count would dent the prosecution's case and would give advantage to the accused. In the instant case, there are irreconcilable contradictions in the evidence of the prosecution side, as well as there are lapses in not following the mandatory procedural requirements for which the conviction of the appellant by the impugned judgment in the considered opinion of this court is not sustainable. So, my lord, even in the instant case, my lord, the mandatory provisions
that list of samples was provided in which provision?
52A, my lord.
List of samples.
Yes,
right?
yes.
You have to give
my lord,
that.
if you just to refresh the memory of this court, my lord, if I may read the section 52A of the NDPS Act, my lord. Subsection 2, my lord. 52A, subsection 2. Where any narcotic drugs, psychotropic substances, controlled substances, or conveyances has been seized and forwarded to the officer in charge of the nearest police station or to the officer empowered under section 53, the officer referred to in subsection 1 shall prepare an inventory of such narcotic drugs, psychotropic substances, controlled substances, or conveyances containing such details relating to their description, quality, quantity, mode of packing, marks, numbers, or such other identifying particulars of the narcotic drugs, psychotropic substances, controlled substances, or conveyances, or the packing in which they are packed, country of origin, and other particulars as the officer required to in subsection 1 may consider relevant to the identity of the narcotic drugs, psychotropic substances, controlled substances, or conveyances in any proceedings under this Act, and make an application to any magistrate for the purpose of A, certifying the correctness of the inventory so prepared, or B, taking in any presence of such magistrate photographs of such drugs or substances or conveyances and certifying such photographs as true, or C, allowing to draw representative samples of such drugs or substances in the presence of such magistrate and certifying the correctness of any list of samples so drawn. Where any application is made under subsection 2, the magistrate shall as soon as may be allowed the application. So, my lord, in this case, application was made to the magistrate, which was allowed. But even in the application itself, my lord, at page 121 of the paper book, the three particulars,
I've seen, yes.
photographs,
Three prayers, but then
3 prayers, my lord.
only one was
Only
done.
one was done, my lord.
And the stipulation made in the bottom of that page relates to a format. It is a
Yes, it's
kind
a
of a format.
prescribed format.
There was
only.
no signature at
Yes,
all.
not at all. There was signature only in the first prayer, that is inventory, correctness of the inventory, that was done.
Let us see what they produce. It might be in their records, but then, okay, let's see.
Yes,
Then
madam.
what did the trial court say?
There is no explanation at all, my lord. The trial court had said that the prosecution has followed the procedure, everything was done as per law, my lord.
Then?
And my next submission is regarding the non-compliance of mandatory provision of section 42, my lord. Here, my lord, the learned trial court had held that all the provisions was followed by the prosecution. But, my lord,
What is the violation of 42 here? Otherwise, 42 requires that you have to make a GD entry and then
yes,
you have to get authorization.
yes,
Then you proceed.
yes. My lord, if I may take you to page 11, my lord, that is the evidence of the complainant, my lord. At para 2, my lord. On 26/10/2020 at around 11:30 a.m., I was at Nathial police station on duty. I received an information through mobile phone that one vehicle is about to take contraband articles from Nathial town, and accordingly I record the information and report the matter to OC Nathial police station. Here I also record the matters in GD number so and so dated 2610. Here, my lord, I have no doubt it was complied 42. But my lord, if you will see at para 3, my lord. Authorization was issued by OC in my favor, and accordingly me and my party performed duty at 3 different places, namely Lunglei Road, Serchip Road and Thingsai Road. After outing for duty, I received another call, my lord.
Achha, you want to say that regarding this there is no...
The subsequent
GD
information was, yes, my lord, was not recorded, not forwarded to the superior officer, my lord.
But there is a provision, no, like if there will be delay.
Yes, exactly, my lord. If there is delay and if there is some explanation, my lord.
Because otherwise they were already on duty on 3 different parts.
Exactly, my lord. Now, my lord.
He receives an information.
Yes.
And he has to rush.
Yes,
he
yes,
cannot
yes.
go to the police station and make GD entry
Yes,
there.
yes, exactly, my lord. But at least if there was some delay in writing the information and sending to the superior officer, that can be done, my lord. But here in the instant case, that was never done, my lord. The subsequent information was never written down or never forwarded to the superior officer, my lord. Now, in support of my submission, my lord, there is one Constitution bench judgment of the Supreme Court, my lord.
Colonel Singh.
Colonel Singh, my lord.
Well-known judgment. Okay.
Yes, yes. There, my lord, there also it explains if there is any delay, then if the officer has written down the cause of the delay and there is some explanation, at least that can suffice. But in the present case, nothing at all, my lord. No explanation, no forwarding, nothing at all, my lord. So it is my humble submission that 42 has not been complied with, my lord.
Then what I mean to say, after they'll have to go immediately on getting the information. They cannot now go to the police station and record.
Yes, yes.
But what I think you mean is that after doing the needful,
yes,
they
yes.
should record the same
Exactly,
in
my lord.
the general diary.
Yes, yes.
That they did not do.
Yes, that they did not do, my lord. I just want to refer one paragraph of Colonel Singh judgment, my lord.
2009.
2009-8 SCC 539. Para 35.
45 you have written here. You have written in your thing as 45 in your written submission.
Yes,
it will be 35.
Yes, 35, my lord. I've made a mistake, my lord.
Yes.
It's in the second last page. Here, my lord, a reference was made to the constitutional bench, my lord. In conclusion, what is to be decided is that Abdul Rashid did not require literal compliance with the requirements of section 42.1 and 42.2, nor did Sajan Abraham hold that the requirements of sections 42.1 and 42.2 need not be fulfilled at all. The effect of the two decisions was as follows. A. The officer, on receiving the information from any person, had to record it in writing in the register concerned and forthwith send a copy to his immediate officer superior before proceeding to take any action in terms of clauses A to D of section 42.1. B. But if the information was received when the officer was not in the police station, but while he was on the move either on patrol duty or otherwise, either by mobile phone or other means, and the information calls for immediate action and any delay would have resulted in the goods or evidence being removed or destroyed, it would not be feasible or practical to take down in writing the information given to him. In such a situation, he could have taken action as per clauses A to D of section 42.1 and thereafter, as soon as it is practical, record the information in writing and forthwith inform the same to the official superior. Here, my lord, this was not done. C. In other words, the compliance with the requirements of sections 42.1 and 42.2 in regard to writing down the information received and sending a copy thereof to the superior officer should normally precede the entry, search and seizure by the officer. But in special circumstances involving emergent situations, the recording of the information in writing and sending a copy thereof to the official superior may get postponed by a reasonable period, that is, after the search, entry and seizure. The question is one of urgency and expediency. D. While total non-compliance with requirements of subsections 1 and 2 of section 42 is impermissible, delayed compliance with satisfactory explanation about the delay will be acceptable compliance with section 42. To illustrate, if any delay may result in the accused escaping or the goods or evidence being destroyed or removed, not recording in writing the information received before initiating action, or non-sending of a copy of such information to the official superior forthwith may not be treated as violation of section 42. But if the information was received when the police officer was in the police station with sufficient time to take action, and if the police officer fails to record in writing the information received or fails to send a copy thereof to the official superior, then it will be a suspicious circumstance, being a clear violation of section 42 of the Act. Similarly, where the police officer does not record the information at all and does not inform the official superior at all, then it will be a clear violation of section 42 of the Act. Whether there is adequate or substantial compliance with section 42 or not is a question of fact to be decided in this case. The above position got strengthened with the amendment to section 42 by Act 9 of 2001. Now, what I would like to stress is that, my lord, the subsequent information, even if there is some delay in writing down or in giving a copy to the...
They should have at least
written down and forwarded to his superior officer, my lord. But that was never done, my lord.
That will be reflected in the case diary, we will see whether...
Yes, but in the evidence, nothing is there, my lord. No explanation at all, my lord. So, my humble submission is that there is a violation of section 42 as well, my lord. And my lord, my last point is that the complainant, who was also the seizing officer, had proceeded to investigate the case at the initial stage, my lord.
No, if it causes bias, okay. Otherwise,
it causes bias because, my lord, as per 161, he had taken some statements under 161 also. It's not in the paper book, but it's in my appeal memo, my lord, that I've annexed in my appeal memo.
those statements are no longer relevant now unless it is contradicted.
Yes.
But this, of course.
But it has caused a prejudice to the appellant as well, my lord, and it vitiates the trial also, my lord.
Now here the IO is different, PW5.
Yes. But
initial. Okay.
I have one judgment with regard to that, my lord. Mega Singh. 1996, 11 SCC 709. Para 4. After considering the facts and circumstances of the case, it appears to us that there is discrepancy in the depositions of PWs 2 and 3, and in the absence of any independent corroboration, such discrepancy does not inspire confidence about the reliability of the prosecution case. We have also noted another disturbing feature in this case. PW3, Siri Chan, head constable, arrested the accused, and on search being conducted by him, a pistol and the cartridges were recovered from the accused. It was on his complaint a formal first information report was lodged and the case was initiated. He, being complainant, should not have proceeded with the investigation of the case. But it appears to us that he was not only the complainant in the case, but he carried on with the investigation and examined witnesses under section 161 CRPC. Such practice, to say the least, should not be resorted so that there may not be any occasion to suspect fair and impartial investigation. So, my lord.
But nothing in the judgment saying that he was the IO in the entire case.
Yes.
That has not been.
That is not there, my lord. Even in the instant case, my lord, some prejudice has been caused to the appellant as well, my lord. So, my lord, to sum up my submission, my lord, there are.
Then you are relying on Hanif Khan's case.
Hanif Khan is also there, my lord. Yes, 2020-16 SCC 709. This is regarding benefit of doubt, my lord. The prosecution has to prove the foundational facts. Even though reverse burden is on the appellant under NDPS Act, but, my lord, the foundational facts have to be established by the prosecution, and the mandatory provisions has to be complied with. But since that has not been done, my lord, my humble prayer is that the impugned judgment and order should be set aside and the appellant should be set at liberty, my lord. Para 8 and 9 of this Hanif Khan judgment, my lord. Shall I read, my lord?
Yes.
We have considered the submissions on behalf of the parties. The prosecution under the NDPS Act carries a reverse burden of proof with a culpable mental state of the accused. He is presumed to be guilty consequent to recovery of contraband from him. And it is for the accused to establish his innocence, like the normal rule of criminal jurisprudence that an accused is presumed to be innocent unless proved guilty. But this does not absolve the prosecution from establishing a prima facie case only whereafter the burden shifts to the accused. In Noor Aga versus State of Punjab, it was observed as follows. Section 35 and 54 of the Act no doubt raise presumptions with regard to the culpable mental state on the part of the accused, as also place the burden of proof in this behalf on the accused. But a bare perusal of the said provision would clearly show that presumption would operate in the trial of the accused only in the event the circumstances contained therein are fully satisfied. An initial burden exists upon the prosecution, and only when it stands satisfied would the legal burden shift. Even then, the standard of proof required for the accused to prove his innocence is not as high as that of the prosecution, whereas the standard of proof required to prove the guilt of the accused on the prosecution is beyond all reasonable doubt, but it is preponderance of probability on the accused. If the prosecution fails to prove the foundational facts so as to attract the rigors of Section 35 of the Act thus rails which is possession of contraband by the accused cannot be said to have been established. Because there is a reverse burden of proof, the prosecution shall be put to a stricter test for compliance with statutory provisions. If at any stage the accused is able to create a reasonable doubt as a part of his defense to rebut the presumption of his guilt, the benefit will naturally have to go to him. So even in the instant case, my lord, there are mandatory violations and as well as many loopholes, my lord. So it is my humble prayer that the impugned judgment and order may be set aside and the appellant should be set at liberty, my lord.
And what about the judgment? You have shown the points only. What is the findings on these grounds? Then none are there. They have not gone into 42, 52.
42 was gone in, my lord, at page 48, my lord, of the paper book. There were only 2 points determined by the learned trial court. That is, one is whether any procedural irregularity was committed by the investigation, and whether the seized articles were...
No, procedure irregularity will include 42, 52.
Yes, exactly,
But 42, 52 was not dealt with.
Not that will specifically, my lord.
Okay.
That's all, my lord.
These are your submissions.
Yes.
Okay. And Miss Mary will reply day
Yes.
after tomorrow.
Yes, ma'am.
It's okay, right? Heard Mr.
Sitlan Thiang Lima.
You are C. So and so for the petitioner, for the
Appellant.
For the appellant. Hearing remain inconclusive. Miss Mary, the learned additional public prosecutor.
Yes.
Additional public prosecutor has some personal difficulty in replying to the arguments put forth by the counsel appearing for the appellant, and as such has prayed the matter to be listed on day after tomorrow. Will be what date? Will be
31st July.
Huh?
31st July.
31st July. Prayer is allowed. List the matter on 31st July for further hearing. You need not take printouts. I will see it from my judgments. Okay, on 31st July. No other matters. Hearing. There was item number 7 today fixed, I think.
They have made a mention for Thursday.
Thursday.
Yes.
Oh, he made a mention in the morning. No other part 2 matters. People are not ready.
No, my lord. Not today.
Okay. Tomorrow there is any fixed matter from the part 2 list? Huh? I think one advocate expired, right?
Yes, my lord.
A young
Funeral
man?
will be held tomorrow.
Funeral tomorrow.
Yes, yes.
He was practicing under married.
No, but they are from the same locality.
Acha.
That's why.
I'm told.
Yes.
My condolences.
Yes. Obliged.
Yes.